This is case number 2018 CA 5321 Kowalski versus Johns Hopkins All Children's Hospital. Let's go ahead and take appearances, starting with the plaintiffs, please.
Greg Anderson and eventually Nick Whitney on behalf of the plaintiffs.
Ethan Shapiro, Howard Hunter, Pat Grohl, David Hughes. Our corporate representative is Dr. Michelle Smith on behalf of All Children's Hospital.
Thank you very much. I have been handed another exhibit list. Is it okay to admit those that have the yes by them?
I would like that very much, Judge. And I will go through.
Any objection from the defense?
No, Your Honor.
Okay, Madam Clerk, the court will receive without objection Exhibit 2123, page 10 only. Exhibit 2123, pages 833 through 837 inclusive. The entirety of Exhibit 2512. And I think that are all of the stipulated agreements on these 4 pages. What's next?
All right, Judge. We have for the first witness under 2149, it's on the first page, about 5 down, Johns Hopkins organizational chart be used with one of our witnesses, Joe Corcoran, our management expert.
Okay, this is the 2012 version.
Yes, and this is the last one that they gave us as available. So we have asked in deposition if there are any more after this.
2012 or 2021? Because this says 2012.
2012.
Judge, I'm sorry, I missed you.
Was this back when it was All Children's, or is it now Johns Hopkins All Children's?
It's now Johns Hopkins All Children's, and it still reflects, I believe, the same organization. Now,
why do we need 2012? Why don't we just start with 2015?
I would like that. I think that would be better. Thank you for pointing that out. I understood that there's a organization, there's a committee roster.
I'm sorry, I apologize. Those look like committee rosters. I was looking at it. So 2012, that's the most recent, is that what
that
you
was
have?
what was represented in deposition by multiple Johns Hopkins people.
I'm sorry, what was the date on that?
2012.
It's the organizational chart.
The organizational chart has been updated since then, and the committee rosters we provided, I believe, were 2016, 17, 18, and 19, but Judge, I failed to see the relevance of any of those.
I have no problem with the committee roster, so court will receive 2142, 2141, 2142, 2143, 2144. Now, is there a organizational chart that is closer to 2015 than the 2012?
I would love to see one from the defense. It was a point of contention through the depositions of the higher ups in the company, Perno, Napolitano, Crane, and there's one other.
Judge, I believe there is. We just got this at midnight last night, so I have to tell you, I have not had a chance to look for it, but I do believe there is a more recent organizational chart.
That's the 2012.
Is there any problem, though, with the 2012?
Only to the extent, Judge, that I don't believe it's been authenticated as being the one that was in effect at the time. Of course, on the other hand, I don't believe that the witness was provided this organizational chart as part of his repertoire.
What, 5-6 years into this litigation, and we don't have the organizational chart from 2015? I mean, I don't see how that's a state secret by any imagine.
No one's taking that position, Judge.
If 2012 is the most recent one that we have, then that's the one we're going to go with. Is if someone can tell me if there's a near to 2015, let's go with that one.
And I'm not opposed, for the record, to substituting out, if we do go, or admitting it again, the 2015. If counsel will produce it, like I said, it's been part of Dukas Tecum requests for a long, long time.
Judge, there have been something like 50,000 pages of documents exchanged in this case. I do not have them committed to memory.
And that's fine.
But I do not believe this is the most recent that was produced. I know that there was a series of them produced at some point, and I can't tell, Your Honor, exactly when that was. I can tell you that there were others produced, and I just don't.
I don't see any harm in admitting 2012, and if we find a more recent one, that's fine. I just don't see how that harms anything.
Very well, Your Honor. If I could, we understood that Dr. Hanna was going to be the first witness this morning. Am I now hearing that Dr. Corcoran is?
No, we're not putting on Dr. Corcoran first. We got, and I should have emailed you, but the decision wasn't made till 11:30 last night. We're not gonna call Dr. Hanna. You don't have to worry about that. But it's not gonna change things because we're still calling Dr. Corcoran, but we're not calling him until the remainder of the people that we talked about are taken care of.
So after they spent all evening preparing for a live witness that you told them that was going to be first up, at 11:30 you make the decision and then you don't even bother to tell them?
Judge,
I mean, how is that?
midnight, it would have been midnight by the time I told them. I did not believe it would be
Judge.
any good. And
Judge, they sent us other things at midnight. They sent us, frankly, this exhibit list at midnight. So, and we get up early and work in the morning for the day's preparation. So that excuse is unacceptable.
The exhibit list was sent yesterday. It was pared down.
Right, I know, agreed. I'm just saying we were working at midnight, as were you.
Just saying.
And we had prepared for him as well. But we made a decision based on speaking with Dr. Hanna and in preparation as part of trial tactics that we think that the jury has heard quite enough about ketamine and about CRPS, and calling yet another doctor.
What time did you make the decision not to call them?
11:30, 10:30, 11:30, because we could not get in touch with him. I actually made the decision earlier, but I could not get in touch with him. And in fact, his office administrator was in touch with me, telling me that he was set to go, and I was like, sure. And we committed it and decided that we don't have the time to put on another 2-hour witness on ketamine and CRPS. And we're down to the nitty gritty here, Judge. We just have to make some tough decisions. And I'm sorry if counsel had prepped on it. They are getting paid to do this stuff, and I've got.
That has nothing to do with it.
I'm
It's
just.
the whole point of telling the other side at lunchtime who's going to be the next day is so they can prepare. Do you know how wrong that what you just said is? You said you'd even determined it earlier, but hadn't talked to Hannah about it. You didn't even bother to tell them. What's wrong with that?
Judge, it was so late, it wouldn't have made any difference in our view. Why call them? And
I'm going to take a break.
11:30.
I'm going to take a break. I want the two of you to talk about what people are coming. There's got to be a different way of than deciding at 11:30 at night, 10:30 at night, 9:30 at night, not telling the other side. That is just wrong. Cannot happen again. I am so tired of how you're not telling the other side information. It's just wrong. We're going to take a break.
All rise for the recess.
Relevance, Your Honor.
Overruled. Court will receive 2159.
If I can backstrike one, we did find 2016.
And what exhibit number is that?
Which one they're using?
It's
Let's see it.
JHACH 19,511.
Is it a identified exhibit, trial exhibit number?
I don't see one on this copy I've been handed, Your Honor.
Okay, in my Zoom feed, I have a person, I assume is a witness, Regina Schimmel.
This is Beata's sister, Your Honor, first witness for us.
Okay, Miss, is she the one that needs an interpreter?
Yes.
Yes, she is.
Do I have the interpreter here?
Yes, Your Honor. He's
Because I need to tell the witness, I'm going to put the witness into the waiting room So can someone come down and tell this witness what I'm doing so the witness understands?
Yes, Your Honor.
Okay. Can we go? Can you just translate this? Good morning, Ms. Schimmel. This is Judge Carroll.
Dzień dobry, pani Chmiel, tu jest sędzia Karol.
Dzień dobry, witam wszystkich zgromadzonych.
Good morning to everyone.
Ma'am, I understand you're going to be a witness this morning.
Rozumiem, że będzie pani świadkiem dzisiaj rano.
Tak, będę świadkiem.
Yes, I will be a witness.
And there's going to be some things I need to do outside of your presence. So I'm going to put you in the waiting room for a little bit, okay?
Są rzeczy, procedury, które muszę wykonać poza pani obecnością, więc umieszczę panią w poczekalni elektronicznej, dopóki pani nie przywołamy.
Dobrze.
Yes, I understand.
Okay, don't go anywhere. I'll call you back in a few minutes, but you're not going to be able to see what's going on.
Proszę nigdzie nie odchodzić od miejsca, w którym pani jest. Za kilka minut sędzia panią wezwie.
Dobrze.
Yes.
Okay, I've removed that witness and put that witness into the waiting room. Thank you, Mr. Interpreter. Okay, what's, so the 2016 bylaws, or sorry, 2006 org chart isn't identified as a trial exhibit?
And now this is the only one we had. We can substitute it.
This was produced to plaintiffs 12/23/20 and 4/28/01.
Well, it's on our list, but it's on this.
That's it.
We just want to make sure it has the same people.
Well, the other organization chart doesn't have the people, it's just got the organization and titles.
Make sure it's the same. Yeah.
We're fine substituting this, Your Honor.
Okay, well, why don't we just put it as the next number in the series? Actually hand it to the clerk. And tell us what number in the series it is, Madam Clerk.
It's 2802.
So the court receives 28/2.
This one has a little bit of highlighted on it. I don't think it matters. Does it matter to you that there's two things highlighted on there?
What's next?
Then we have the Johns Hopkins medical record access log for October 8th, 2016. This has to do with the Kathy Beatty and the access to Maya's medical records without authorization from the parents.
Is this only access to Maya Kowalski's file? So I don't have to worry about any other patients' HIPAA issues?
Correct.
Okay, let's go ahead and put it up, please, so I can look at it.
The access log in question, Judge, this has come up before, and we had, the issue before was authentication and explanation. The purpose that I understand this being offered for is to demonstrate that Sally Smith accessed the medical record on or about October 8th, 2016, to which we are prepared to stipulate. This thing, if you, as you'll see when it's up in front of you, has got 9 or 10 different columns with 9 or 10 different explanations. It's not susceptible of ready interpretation without someone who knows what it says. And so we object to their just putting it in without authentication or without explanation or context of what the various columns and information tranches mean. But once again, we're prepared to stipulate that Sally Smith did in fact, pursuant to her status as a staff physician and CPI investigator, access the chart. They don't need to put this in. That's agreed to.
We would prefer to have the written document in evidence in case there is a dispute either on appeal or otherwise as to the scope of any stipulation and any issues that could come up during the defendant's case or rebuttal countering this. So with all due respect to counsel, we prefer to have this actually in, and we do have the codes, and they're not particularly difficult to ascertain. On behalf of Maya Kowalski, we waive any confidentiality for these purposes.
Well, There's no authentication issue. I mean, I think the parties have agreed that this is the access log.
It is the
And
access log, Judge. The
if you
question
would-
is what the various columns mean. And what I'm concerned about is some element of surprise and quote interpretation of these things without context and without reality and challenging it.
You can call a witness to explain the meaning of this, but the reality is they are contending that Dr. Smith is the apparent agent of the hospital, and this directly is evidence of their contention. So, or potentially, arguably. Well, you can make all faces you want,
Well,
Mr. Hunter.
I understand, Your Honor, but
Let's
there's
not-
no
let's not do the
authentication.
faces,
I'm
okay?
sorry.
Not today.
There is no indication that there was any connection between her accessing this chart and her status as an apparent agent.
You can argue that to the
Okay.
jury. They don't have to take your stipulation. I mean, they don't have to take the stipulation. They didn't take it, so the court will receive 2165A as an alpha -071, that page only. What's next?
2249, JH policy, HIPAA policies for providers, authorizations. They had raised an objection. I'll let them do it, but it's relevant and material for the same reason as the item before, the exhibit before, in order to interpret 2165A-071, 2249 with the codes and the HIPAA policies would be necessary.
Well, there is no cause of action for HIPAA violation in this complaint. I just,
That was my concern, Judge. I'm not sure why they're putting in and why that's relevant to the other. I mean, it's all about HIPAA. So,
And Your Honor, to the extent there's going to be an argument that there was a HIPAA violation by accessing the chart on 10/8/16, we have a pending motion. And me about that. Plaintiffs never filed a supplemental brief this court requested. And I think we're at some point today before Dr. Colquhoun prepared to argue how this is absolutely not a HIPAA violation under Florida statutes or the Code of Federal Regulations. And even if it was, there's a Florida statute that says we're not even supposed to be talking about that in malpractice court.
well, again, there's no cause of action for a HIPAA violation, so.
Mine's only for the codes, Judge. If we can pare it down to just having the codes, I want to make sure.
What do you mean by the codes?
No,
I'm looking at the policy. What are you talking about?
it was my understanding that within this document, it set forth the rules and regulations and how to code it. But if it doesn't, then for now, we can withdraw. We need to move on anyway, Judge. So we'll withdraw for now. And then come back to it.
What's the next one?
2056 is at the top of the list. I think that was skipped. Can you put that up for us? This reflects one of Sally Smith's various roles within the hospital this time. As part of the residency program at Johns Hopkins, goes to our parent agency discussion.
Judge, no objection except for the highlighting.
Well, okay, this is not our highlighting. This is how it was discovered.
I said, Jeff, you said no? Okay, I'm sorry. Excuse me, Your Honor. We do object to the relevance. And who's going to make it relevant?
Is this like a published list? And
Yes.
yeah, no,
Okay.
the court's going to overrule the relevance. I will
Okay.
receive 2056. And you don't have a version that doesn't have the highlighting on it?
No, that's how it was. I mean, we can try to remove it if it's necessary.
Well, Judge, highlighting can be removed pretty easily anymore on PDFs.
Well, again, it's what the clerk has. The clerk probably has it highlighted.
Substituted in, then perhaps.
You tell me, everyone.
We prefer not to do it. Well, we'll do what the court requires, or if they require the highlight be removed, we'll work on that.
That one, I mean, out of all the things to worry about in this case, I don't think this is
I
one.
appreciate that, Judge. All right.
Your Honor,
This is the art of the possible.
Yes.
in the interest of time, we'd like to, and I think we're going to have a lunch discussion, we'd like to move down to the second to last page of the list, Exhibit 2277, which begins with the risk management file. And within that, I'd like to move, I guess I'm on the last page now, page 628 and 629.
I'm sorry, what?
All right.
Because this list isn't in chronological order, so let me just find it.
Well, it's, so 2277, and within 2277, there are several hundred pages. So if you go to the
I got
third to
you.
last entry, 628, 629, and this is an internal email at Johns Hopkins regarding Maya's care and treatment.
Judge, it's an internal email that refers to Attorney Hunter that talks about the dependency action.
Is this the one that I already ruled on, or is this a different email?
This is a different one, Your Honor.
It's the same issue, Judge. This is all talking about testimony at the dependency hearing. And then refers to, in the second paragraph, Attorney, okay. Refers in the second paragraph to Attorney Hunter.
Okay, well, let's go, in my mind, the first thing is, can I see the two in the front again? Are any of these individuals, Jackie Crane's, is she the, remind me, she's the nurse or?
She's the general counsel.
General counsel. So the first issue is attorney-client privilege, but then there was the issue of inadvertent disclosure. But was this document included in the inadvertent disclosure?
No.
Okay. So effectively, we've got a waiver of attorney-client privilege here at this point. Is that where I'm at?
There's not an express attorney-client communication here other than what I was allegedly advised of. The real objection here, Judge, is going to be with the DCF matter, because this is replete with that entire matter.
Okay. So in my mind, I've moved on beyond attorney-client privilege. Now I'm going to go to the relevance. Can you make it the text larger, please? Mr. Harris, thank you. There's going to have to be a couple of redactions in this email.
Understood.
But the balance of it is going to come in. What date is this again? December 30th. And where were we on the dependency court orders with respect to visitation?
I believe the most recent order before this email was a December 27th order. And
well, there's a reference in here about exercising the right to supervise. Was that permitted under that?
Under that order was the first time, to my recollection, that the hospital was granted express permission to supervise those calls.
In the order, Judge, as opposed to DCF asking them to do it, but they are expressly allowed to supervise.
I have the
I
word.
think the sentence that starts, Maya was not allowed to listen in, that sentence has to come out.
Right.
The following sentence, the judge didn't let Maya listen in,
Yes.
needs to come out. And is there any, is this sentence correct that mom's mother is allowed unsupervised FaceTime at 11 a.m. and 5 p.m.?
Judge, I'd have to look at the order specifically. I think they mean Maya's mother.
I have.
Well, it's Beata.
Yeah.
It's a paragraph 2 of the order. Mother shall have and ACH shall permit visit by any electronic device, i.e. iPhone, Skype, FaceTime, or similar method at approximately 11 a.m. and 5 p.m. daily. Such communication may be supervised by a guardian ad litem, the child's case manager, or any member of the hospital staff, but does not have to be. And I can read the balance if the court wants. There's a few other points.
Why don't we just redact where it says mom's mother through the balance of that paragraph?
So the rest of that paragraph, Your Honor, comes out?
Yes, and then the following paragraph, let's redact, but leave in, I did advise Dr. Majors to get pictures of the scratches.
Okay.
And
Sorry, Judge. The second
wait a second,
sentence.
the sentence, the third sentence of that paragraph where it says Howard also agreed, that sentence needs to come out.
Understood.
But the talking about getting pictures of the scratches and an inquiry to how Maya got them needs to stay in.
Your Honor, in the paragraph above that begins, I just got off the phone with the case manager. The second sentence reads, everyone is over this case, or can we keep that?
Yeah, Judge, that's referring to the DCF case.
It's referring to
And
it,
it's
but
out of perspective if the rest of it's removed.
I agree, that sentence without the context of the sentence before or after could be misleading.
Understood.
So, okay, are we clear on what needs to be redacted?
Yeah, we'll put it best then.
Okay, so we'll need to get to the clerk a printed copy of it. So ultimately, I will be admitting, and we'll call it A on that
I
one.
will also need the
So 628-629A.
testimony of Joe Corbin.
629.
I'm only looking at one page, so where's the second page?
The second page is just a continuation. It's nothing more than, I think, a logo. So,
Can we see the second page?
Second page thing.
Okay. No, we're gonna leave in the logo. So, yes, ultimately, it'll be received as 2277-628A and 629A. But it'll be redacted. Okay. Is there anything that we have to do before we bring in the jury?
I think we can wait.
Your Honor, I did, as a threshold matter for the witness that's coming, I did want to.
Who's coming?
The next witness that's coming.
Tell me who the next witness is.
Regina.
Oh, that's right, that's right,
Regina,
okay.
yeah, Regina. There is a tremendous amount of hearsay. I anticipate being on my feet quite a bit. Almost everything that this witness knows during the hospitalization came through hearsay conversations from essentially Beata Kowalski. So I don't know exactly what she's being proffered for, but her universe of knowledge in terms of personal non-hearsay interaction is essentially nil. I don't know where we're going with this. Just like some clarification from the voter council.
Great. I don't think this is going to intrude on what Beata told her about the hospitalization. I think that's the purpose of the testimony.
The only thing I can think of is how did you learn about Beata's death, which is not exactly, it's just a name, date, and would be an exception to hearsay, I believe, under statements regarding reputation, statements regarding personal or family history. And birth, marriage, divorce, death, relationship.
Sounds like they're not going to ask about statements she was making inside the hospital. So
Well, like they told us what, she's not being proffered for. I'd like to hear a little bit about of what she's being proffered for. And again, the admonition too is it's not just what happened in the hospitalization, but there's a lot of deposition testimony here about what Beata told the witness about what was going on.
I don't want to go through her whole testimony outside the presence of the jury and then have to redo it again on a witness that also is going to need the services of an interpreter.
All right.
So let's. Madam Clerk is asking about 2159. 2159 is in evidence, and we got the 2016 org chart, which is 2802 in evidence, so we don't need 2149. Is that correct?
I'm sorry.
The clerk wanted to know about 2149, and my recollection, since we put in the 2016 org chart at 28049. You're welcome, Madam Clerk. Okay, let's do this. Let me have the clerk swear the interpreter in. I will then swear the witness in outside the presence of the jury, and then I will tell the jury, like I've done with the other witnesses, that I swore the witness outside the presence. Come on down, Mr. Interpreter.
Stand here.
Debbie Coley. Oh, we don't need a chair here.
Do you solemnly swear or affirm that you will make a true interpretation of the questions asked and the answers given, and that you will make a true translation of any writing which you are required by your duties to decipher or translate?
I do.
I'm going to bring in the witness. And are you fine standing there, or do you?
Yes, I'm fine.
Sit down. If you get tired and need to sit down, let us know. We'll
Thank you.
make that work for you.
All right, I guess I'll stand over here. Stand next to him.
Why don't you go to that lectern, and then Mr. Anderson can go to this lectern.
Okay. Your Honor, I'm just have a better view of the monitor here. Does that matter or not for the?
Well, I tell you what, why don't you come sit on the witness stand?
Okay.
There's a monitor there, and I will. Do you see that?
Yeah.
Okay. Good morning again, Miss. Is it Chimmel?
Dzień dobry, pani Chmiel.
Dzień dobry, witam.
Did I say that properly?
In Polish, it's pronounced Chmiel.
Camille?
Close enough.
No,
I'm sorry.
I try to get everyone's name right.
Chmiel. Chmiel.
Camille?
Yeah. That's perfect.
Miss Camille? My understanding is you currently are in the Chicago area. Is that correct?
Rozumiem, że pani w tej chwili jest w obszarze blisko Chicago. Czy tak jest?
Tak, mieszkam w Chicago.
Yes, I am in Chicago area.
Under our rules, since I am a judge in the state of Florida,
Ponieważ ja jestem sędzią w stanie Floryda,
I need your permission to administer the oath before you testify.
potrzebuję, żeby pani się zgodziła na dokonanie przysięgi, zanim pani będzie zeznawać.
What that means for you is if there was ever an enforcement action or a perjury action,
Dla pani to znaczy to, że jeżeli kiedykolwiek ktoś niósłby jakąś akcję o krzywoprzysięstwo
against you based on your testimony here today,
przeciwko pani na podstawie tego, co pani dzisiaj zeznaje,
you are agreeing to personal jurisdiction in Sarasota County, Florida.
zgadza się pani na to, żeby taka akcja sądowa, jeżeli by była taka, miała miejsce w Sarasocie, w Florydzie.
Because even though you were sitting in Chicago, you were actually testifying in Sarasota County, Florida.
Dlatego, że mimo to, że pani w tej chwili siedzi w Chicago, to zeznaje pani w Sarasocie na Florydzie.
Okay, rozumiem.
I understand.
With that understanding, do you agree I can administer the oath to you?
Rozumiejąc to, co powiedziałem, czy zgadza się pani na przysięgę?
Tak,
I do.
Please raise your right hand.
Proszę podnieść prawą rękę.
Do you solemnly swear or affirm the testimony you give is the truth?
Czy pani przysięga, że wszystko to, co pani powie w zeznaniach jest prawdą?
tak.
Jest.
Thank you, ma'am.
Dziękuję pani.
Let's bring in the jury.
Your Honor, I'm sorry, did I miss it? I don't remember you swearing in the interpreter. But you did do
The
it?
clerk swore the interpreter.
Oh, I'm sorry, my apologies.
Okay, let's bring in the jury.
Prowadzeni będą ławnicy.
All right, jurors entering.
Okay, everyone, please be seated.
Siadają.
Okay. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that correct? And have you been approached by anyone about this case since you were with us last? No. And have you reviewed any media coverage of this case since we were last here?
Sędzia sprawdza, czy ławnicy z nikim nie rozmawiali.
And y'all doing okay this morning? I asked a different question. Are y'all doing okay this morning? Trying to keep you on your toes. Okay. Members of the jury, our next witness is testifying from the Chicago area.
Nasz następny świadek zeznaje z Chicago.
And needs the services of a Polish interpreter.
Potrzebuje usług tłumacza polskiego.
Outside of your presence, I have sworn in both the interpreter and the witness.
Poza waszą obecnością przysięgi dokonał i tłumacz, i świadek.
So the witness will be testifying under oath just like every other witness has.
Świadek będzie zeznawał pod przysięgą, tak jak każdy inny świadek w sprawie.
Mr. Anderson, you may inquire.
Panie Anderson, może pan zadawać pytania.
I hope you do not mind if I just call you Regina.
Mam nadzieję, że nie będzie pani miała nic przeciwko temu, jeżeli będę się do pani zwracał jako Regina.
Dobrze, miło mi.
Thank you, it's a pleasure.
You're Beata Kowalski's sister.
Czy pani jest siostrą Beaty Kowalskiej?
Tak, jestem.
Yes, I am.
Where do you live?
Gdzie pani mieszka?
Mieszkam w Chicago.
I live in Chicago.
How long have you lived there?
Jak długo pani tam mieszka?
21 lat.
21 years.
And where did you live before that?
Gdzie pani mieszka uprzednio?
Mieszkałam w Polsce.
I lived in Poland.
And when you moved, was Poland still under communist rule?
Kiedy
had it been freed?
Kiedy pani przeprowadziła się do Stanów Zjednoczonych, czy Polska jeszcze dalej była pod władzą komunistyczną, czy już została wyzwolona?
Już została wyzwolona.
It had been freed.
For how long?
Jak długo?
Miałam 28 lat, jak w Polsce został obalony komunizm.
I was 28 years old when communism was toppled in Poland.
And how old would Beata been then?
Ile lat miała wtedy Beata?
Jak został obalony komunizm w Polsce, moja siostra miała 16 lat.
When communism was toppled in Poland, my sister was 16 years old.
So both you and your sister lived into your teens under communist rule?
Więc zarówno pani, jak i pani siostra, będąc nastolatkami, żyły pod władzą komunistyczną.
Tak.
Yes.
And did that shape Beata's view of life from what you saw?
Czy to przeżycie w jakiś sposób ukształtowało poglądy Beaty na życie z tego, co pani mogła zobaczyć?
Tak.
Yes.
Nasi rodzice mówili nam, że trzeba walczyć o ważne sprawy. Nasz tata w czasie komunizmu należał do Związku Zawodowego Solidarność 1980.
Our parents told us that we should fight for things that are important to us. Our father belonged to the Solidarity Union movement.
Nasz tata był jednym z liderów tego ruchu, który walczył o prawa ludzi i walczył z komunizmem.
Our father was one of the leaders of the movement that fought for human rights and fought against communist rule.
Ma'am, are you reading off of something? This is Judge Carroll.
Sędzia pyta, czy pani czyta z notatek.
Mam notatki i patrzę, żebym po prostu powiedziała dobrze. Mogę korzystać z notatek moich?
I made some notes. I just want to make sure that I'm saying what I'm saying correctly. Am I allowed to use these notes?
Well, let's turn over your notes and not use them. If you need to use them, let us know beforehand, okay?
Sędzia prosi, żeby pani odwróciła notatki do góry nogami, nie używała ich. Jeżeli pani będzie je potrzebowała, proszę o tym powiadomić sędziego. Yes, Your Honor.
Not to get into too much of a history lesson, but was the solidarity movement under Lech Walesa the beginning of the fall of communism in
Nie
Eastern
chcemy
Europe?
tutaj wchodzić w lekcję historii, ale chciałem pani zadać pytanie, czy ruch Solidarności pod kierownictwem Wałęsy był jedną z przyczyn upadku komunizmu.
Interpreter, hold on a second.
I want to check the relevance of this last.
Sustain. Tell her not to answer that question.
Ma pani nie odpowiadać, dlatego że adwokat strony drugiej wniósł sprzeciw, sędzia ten sprzeciw uwzględnił, że to nie jest istotne.
From the way that you and your sister were raised, do you believe that there was an inherent distrust of government from being under communist rule?
Czy z tego, tak jak pani i pani siostra były wychowane przez rodziców, czy zgodziłaby się pani z tym, że był jakby zakodowany brak zaufania wobec instytucji rządowych?
Nie wiem, na ile moja siostra pamiętała, ale myślę, że miało to duży wpływ na nią, ponieważ nasz tata został internowany i osądzony w więzieniu jako więzień polityczny i nie było go pół roku.
I don't know exactly how much of this affected my sister, but I assume, I would think it had affected her because our father had been imprisoned by the government authorities for a period of 6 months.
Nasz tato został internowany w grudniu, 13 grudnia 1981 roku na oczach swoich małych dzieci.
Our father was interned on December 13th, 1981. He was arrested, taken in while his small children were watching this happen.
Tato został zabrany z domu i nie wiedzieliśmy, gdzie on przebywa.
Our father was taken from his house and we didn't know where he was being taken to.
Go ahead. She can continue.
To na pewno było wielkie przeżycie dla niej, dla 8-letniego dziecka. Jeszcze do tego naszej mamy nie było, bo kilka miesięcy wcześniej pojechała do Stanów Zjednoczonych.
It was a very impactful experience for an 8-year-old. My sister was 8 years old.
Finish out
Additionally, so because our mother had not been at home, she was in the United States at the time.
Okay, ma'am, we need to wait for the next question before we say anything else.
Musimy czekać na następne pytanie, pani musi czekać na następne pytanie, zanim pani będzie kontynuować od pytania do pytania.
Your Honor, I'd like to state my objection on the basis of relevance, non-responsive to the question asked.
Adwokat chciał mieć sprzeciw, mówiąc, że na bazie istotności.
I'm going to overrule, but ma'am, you just need to wait for the next question. before you say
Sędzia
anything.
nie zaakceptował sprzeciwu, ale musi pani czekać na następne pytanie, a odpowiadać tylko na pytanie, które jest zadane.
Were you and your sister taught to assert yourselves in order to get something done with a bureaucracy?
Czy panią i pani siostrę uczono tego, żeby być asertywnym, żeby być pewnym siebie w konfrontacji z biurokracją, żeby po prostu domagać się swego?
Overruled, she can answer.
Może pani odpowiedzieć.
Myślę, że tak. Rodzice nam wpajali to zawsze, że trzeba walczyć o swoje i stawiali nasi rodzice na edukację nas.
I believe so. Our parents always taught us to stick up for ourselves and to educate ourselves as best we could.
So, was the Roman Catholic religion important in your family?
Czy wiara rzymskokatolicka, religia była ważna w rodzinie pani?
Tak, była bardzo ważna i jest.
Yes, it was and still is very important.
How often did you get to see your sister once she moved to the United States?
Jak często widywała pani siostrę od czasu, kiedy ona przeprowadziła się do Stanów Zjednoczonych?
Kiedy ja przyjechałam ze swoją rodziną do Stanów Zjednoczonych, Beata wyszła za mąż i założyła swoją rodzinę i spotykaliśmy się bardzo często.
After I had moved to the United States, Beata had married. She had her own family, and we met very frequently.
Is that how you pronounce Beata's name in Polish?
Czy tak się wymawia imię Beaty po polsku?
Beata, a w domu mówiliśmy na nią Benia.
The Polish pronunciation is Beata. At home, she was called Benia.
So, did you have the opportunity to observe Beata's interaction with her children, with Kyle and Maya?
Czy miała pani okazję obserwować interakcję między Beatą a jej dziećmi?
Tak, Beata, jak mieszkała na przedmieściach Chicago, w Elmhurst, tutaj urodziły się jej dzieci. Spotykałyśmy się bardzo często na urodzinach swoich dzieci, na świętach. Pomagałyśmy sobie nawzajem. Była bardzo dobrą matką.
Przepraszam. When she was married and had children, we would meet very often. We would meet for family holidays and on other occasions. She was a very good mother. We met quite frequently.
And when you spoke, did you speak Polish?
Kiedy spotykałyście się, czy mówiłyście po polsku?
Tak, mówiliśmy po polsku. Jej dzieci chodziły do polskiej szkoły raz w tygodniu, by uczyć się języka polskiego i Beatka mówiła zawsze do nich po polsku.
Yes, we spoke Polish. The children went to Saturday school to learn Polish, and Beata always spoke to them in Polish.
At the time Beata passed, how well were the children doing in communicating with the rest of the family in Polish?
Wtedy, kiedy odeszła Beata, na ile z powodzeniem mogły się komunikować dzieci z resztą rodziny po polsku?
Kiedy po tragicznej śmierci mojej siostry kontakt z jej dziećmi był bardzo znikomy.
After the tragic death of my sister, the contact that we had with her children was very sporadic.
Before that, were they coming along in the Polish language so that you could communicate easily directly with them?
Pytanie jest, czy przed śmiercią Beaty, na ile dobry był ich polski, czy mogła pani się z nimi swobodnie porozumiewać w języku polskim?
Tak, mogłam się porozumiewać, spotykałyśmy się, przytulaliśmy się nawzajem. Dzieci bardzo mnie lubiały, naszą mamę, babcię.
I could freely communicate with them in Polish. We hugged, we had a very good time. They were very close to me and their grandmother.
And when was the last time you spoke with either Kyle or Maya?
Kiedy to było ostatnim razem, kiedy pani rozmawiała albo z Kyle, albo z Mają?
Z Mają i z Kajem wysyłamy sobie text message, bo najlepiej nam się w ten sposób porozumiewać. Nie dzwonimy do siebie, tylko SMS-ujemy.
Yes, Your Honor.
Is one of the two techs running this through the system so the jury can see? Okay.
Pytanie jest, czy jurorzy widzą pani obraz. Teraz się pani obraz pojawił.
Catch.
O, zniknęłam.
Sorry about that.
My God.
Should I interpret the question?
I can't even remember the question.
The question was whether Ms. Camille had when was the last time she had communicated with the children?
That was the question, please.
Kiedy pani, jeszcze raz jak pani odpowiedziała na to pytanie, kiedy pani ostatni raz miała kontakt z dziećmi?
Z dziećmi mojej siostry kontaktujemy się codziennie przez SMS-y. Nie dzwonimy do siebie, dlatego że one nie mówią już po polsku, a ja tylko troszkę mówię po angielsku.
I contact the children regularly. We communicate through text messages. We contact each other every day. Text messages are a better mode of communication because the children no longer speak English well, and I don't speak. No longer speak Polish well, and I don't speak English well enough to have a fluid conversation.
So without Beata, has it become more difficult for the children to communicate with your side of the family?
Czy bez Beaty jest w tej chwili trudniej dzieciom komunikować się z pani stroną rodziny?
Tak, teraz jest bardzo trudno, dlatego że Beata, moja siostra, była łącznikiem między nami. Ona mówiła
may I ask the witness just to,
Yes,
no more than 2 sentences. Proszę panią, nie więcej niż 2 zdania, tak jak się umawialiśmy, bo mnie potem jest trudno wszystko przetłumaczyć. Yes, the exchange has become much more difficult right now because Beata was the intermediary who was bringing us together, so it is more difficult now.
Did you have an opportunity to observe your sister's interaction with Maya and Kyle on those occasions you were together?
Czy miała pani okazję obserwować Beatę w relacjach z jej dziećmi, z Kyle i z Mają w tych momentach, kiedy byłyście razem?
Tak.
Yes, I did.
Describe for the jury, from your position as an aunt, how Maya interacted with her children. What kind of mother was she?
Jeżeli pani mogłaby opisać ze swojej pozycji jako ciocia, jak Beata, jaka była interakcja między Beatą i jej dziećmi, jakiego rodzaju była mamą?
Jak Kajo, drugie dziecko, Beata urodziła, jak pamiętam,
When Beata gave birth to the second child, Kaya, I remember.
Jej dziecko miało problemy z krwią jako noworodek.
The child had problems with blood as a toddler.
I Kajo został zabrany do innego szpitala po porodzie.
And Kaya was taken to another hospital immediately after birth.
To ona wypisała się ze szpitala położniczego i pojechała za nim.
Beata had signed herself out of the OB hospital she was with, and she went with the child.
Chory Majo miał, co pamiętam, 8 razy przetaczaną krew od swojej mamy. I ratowała jego życie.
When Kyle was ill, he had 8 blood transfusions. Transfusions that were the source of the blood was the mother's blood, and that saved his life.
A z tego co pamiętam, Beata, moja siostra, była bardzo dobrą matką. Pamiętam, jak założyła dla niego taką książeczkę.
From what I remember, Beata was a very good mother. I remember where she instituted a booklet for him.
Taki pamiętnik, jak była w ciąży, prowadziła pamiętnik dla małego Kaja.
It was a diary that she had written while she was pregnant for her child to read in the future.
I jak pewnego razu byłam u niej na wizycie i oglądałam tą książeczkę, jak ona dokładnie pisała, co czuła, jak go nosiła pod swoim sercem.
One of the times when I was there, I had a chance to look at the booklet and read it, and she was very precise in recounting how she felt when she carried him under her heart during her pregnancy.
Pisała praktycznie każdego dnia w tym pamiętniku do Kaja. Pisała go swoją ręką i swoim sercem.
She wrote practically every day. She wrote with her heart and with her hand.
Natomiast Maja, jej córeczka, bardzo ją kochała.
She loved her daughter Maya very, very much.
Maja, gdy była tutaj zdrowa w Ermkus, razem z rodzicami jeździła na łyżwach. Byliśmy na takim pokazie na tych łyżwach.
When Maya was healthy, she would go with her parents to go ice skating. We went to see ice skating shows.
Słuchaliśmy jej nagrań, ponieważ Maja pięknie grała na pianinie.
And Maya played the piano very, very well, wonderfully. So we would listen to recordings of her playing the piano.
Kiedy Maja z rodziną przeprowadziła się na Florydę do Venice.
When Maya with her family had moved to Florida, to Venice.
I wkrótce, myślę, że tak 2 lata.
And within, I think, was 2 years.
Maja zachorowała.
Maya became sick.
I Beata informowała nas i opowiadała o wszystkim, o jej zmaganiach z tą chorobą.
Beata informed us about all the details. She told us about all of Maya's struggles in fighting the ailment.
Ma'am, you need to wait for the next question.
Proszę poczekać na następne pytanie.
From what you saw, understanding most parents hopefully have a strong parental instinct. Did Beata have a particularly strong parental protective instinct towards her children?
Z tego, co pani
Because of what
widziała,
she'd been through.
I'm going to check the foundation.
Going to overrule that. You can translate.
mogę przetłumaczyć, sędzia pozwolił. Pytanie było takie, że zakładając, że większość rodziców ma instynkt opiekuńczy wobec swoich dzieci, czy powiedziałaby pani, że Beata miała wyjątkowo silny instynkt opiekuńczy wobec swoich dzieci?
Beata była zwykłą mamą, tak jak wszystkie dobre mamy.
Beata was a normal mother, just like any other good mother. I'm not sure that the witness understood your question.
Can you translate the parental instinct to protect her children? And I'm trying to ask, was Beata's more than normal?
Just ask a normal question, and he'll translate.
I'll try it.
I'll object to the extent this is calling for character evidence.
You'll need to translate our discussion. Just ask your next question.
Right. Did Beata have a strong instinct to protect Kyle and Maya from what you saw?
Okay, I'm going to sustain the objection. Let's go to the next question.
All right.
W tej chwili podtrzymał obiekcję sędzia, więc przechodzimy do następnego pytania.
So since Beata's death, how much less you've testified you see them less. How much less are you able to see Kyle and Maya and they you?
Od czasu śmierci Beaty, na ile mniej jest pani w stanie widywać się z dziećmi, na ile mniej one są w stanie widywać się z panią?
Po śmierci Beaty widziałam dzieci 2 razy.
After Beata's death, I had seen the children on 2 occasions.
Razem z moją rodziną, z moją mamą, która je wychowywała. Mama moja do tej pory bardzo rozpacza, że nie widzi swoich wnuków, którymi się opiekowała.
When I had seen them, I was in the company of my mother, their grandmother, who raised them, who also raised them, and she is despondent about the fact that she can't see them more.
Brings up a good point. Now, who is in the United States from your side of the family that the children would be able to interact with?
Kto jest w tej chwili od pani strony rodziny w Stanach Zjednoczonych, tak żeby dzieci mogły mieć jakby interakcję, widzieć się z tymi osobami, które są w Stanach Zjednoczonych?
My tu mieszkamy wszyscy. Jest moja druga siostra Elżbieta, jest mój brat Piotr.
Momencik. We all live here. There's my sister Elżbieta, my brother Piotr. Proszę.
Jest siostrzenica Klaudia.
There's my niece Claudia.
I moje dzieci, a mam ich 5.
And my children, and I have 5 children.
Wszyscy czekamy na wizyty Mai i Kaja.
We all eagerly await Maya's and Kyle's visits.
Any cousins around their age?
Czy
Maya and Kyle's?
Czy są kuzyni mniej więcej w ich wieku? Maja i Kyla.
Moje dzieci są dużo starsi. Mój syn jest ojcem chrzestnym Kaja.
My children are quite a bit older. My son is Kyle's godfather.
And so now has that contact with your side of the family been reduced now that it's been a few years since Beata's passing?
Pytanie jest, czy od śmierci Beaty ten kontakt został zmniejszony?
Bardzo został zmniejszony.
It has been reduced to a great degree.
Po śmierci Beaty rodzina się rozsypała. Wszyscy po prostu nie mogą sobie z tym poradzić.
After Beata's death, the family fell apart. We can't cope with the situation.
Is there any doubt in your mind that Beata would give her life for her children?
Czy ma pani jakiekolwiek wątpliwości, że Beata oddałaby swoje życie za dzieci?
Objection, relevance, foundation.
Establish the foundation.
Call for character evidence as well.
Sustained.
Nie mogę tego, sędzia nie pozwala na odpowiedzi na to pytanie.
And do you hope for more communication with Maya and Kyle in the future?
Czy ma pani nadzieję na to, że będzie pani miała więcej kontaktu z Kyle i z Mają w przyszłości?
Mam nadzieję, że się będziemy spotykać.
I'm hopeful that we will be able to meet. Proszę dalej.
Może już wkrótce przyjadą do nas na wesele.
Hopefully, maybe they will come to visit us soon for the wedding.
Your witness. Thank you, Regina.
Mr. Hughes, your turn.
Teraz będzie adwokat obrony zadawał pani pytania.
May it please the court. Good morning, ma'am. Thank you for coming in. I'm sorry for your loss.
Dzień dobry pani, dziękuję za to, że się pani pojawiła. Jest mi przykro z powodu straty, jaką pani doznała.
Does Mr. Kowalski, Jack Kowalski, make arrangements for you and the family here in Florida to get together?
Czy pan Kowalski, Jack Kowalski aranżuje takie możliwości, żeby pani rodzina mogła się spotkać z dziećmi?
Trudno mi powiedzieć, dlatego że to Beata była tym łącznikiem, jak żyła.
It is difficult for me to say because Beata was the instigator of family gatherings.
To jest, my mieszkamy w Chicago, oni mieszkają w Venice.
We live in Chicago, they live in Venice.
My mówimy w języku polskim, troszkę po angielsku tylko.
We speak Polish, just a little bit of English.
Jacek mówi tylko po angielsku, nie mówi po polsku.
Jacek speaks only English, he does not speak Polish.
When was the last time that Mr. Kowalski made attempts to meet with the side of the family that's in Chicago?
Kiedy ostatnim razem pan Kowalski próbował się spotkać z rodziną, która mieszka w Chicago?
Jacek z dziećmi po śmierci Beaty był tutaj 2 razy z wizytą.
After Beata's death, Jacek and the children were here in Chicago twice.
I don't have any other questions. Thank you, ma'am.
Nie mam więcej pytań, dziękuję.
Mr. Anderson, any more questions?
Nothing further, Your Honor.
Pan Anderson też nie ma więcej pytań.
Hold on a second, ma'am. The jury might have questions.
Jeszcze pani poczeka, bo być może ławnicy będą mieli pytania.
Members of the jury, anyone have questions?
Ławnicy nie mają pytań.
Okay, seeing no questions, may this witness be excused at this time?
Yes, on behalf of plaintiff.
Ponieważ nie ma więcej pytań, czy możemy podziękować świadkowi?
Thank you for being with us, ma'am. You're free to go.
Dziękuję za to, że pani była z nami. Może pani już skończyć swoje zeznanie. Thank you. Thank you, Your Honor.
Thank you, sir. You can step
Thank you,
down.
Your Honor.
And your next witness.
Laura Vose by deposition.
Judge, can we approach briefly?
Sure. And this one's on video as well? This deposition's on video?
Yes, Your Honor.
Oh, Your Honor, I do ask, I'm sorry, can we tell the jury the date the depositions are taken? Because it's not, can we
It's on the
approach?
bottom of the screen, but
Okay.
I think he's gonna.
Sure, the answer is yes. See if I can do the lights again. Is that too much light over there? Tell me, I'll keep adjusting it.
Alexa, 20%.
That's the right one.
And we get a light show.
Like I said, there's like 9 switches here. Or not switches, buttons. Okay, let's play the next deposition, please. That lady, you know how to do the lights? No.
Judge, should we do an instruction? This may be our first, is this our first depo?
No.
Oh, sorry.
I'll just tell you the instruction anyway. As a reminder, depositions were done under oath prior to you coming here. You're to treat them just like all the other evidence in this case. There you go.
You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record.
Laura Ann Vos,
And is that an MD?
DO,
And what the DO stands for again?
Doctor of Osteopathy.
And at your present hospital, are you on any committees?
Yes.
What committees?
I am on the ethics committee. I am on a pediatric surgical performance improvement committee.
Okay. Dr. Vos, we are, as I said, in follow-up to your last deposition, I think your only deposition in this case, which was taken Thursday, November 14th at 2019. Do you remember giving that deposition?
Yes.
And have you had the opportunity to read that deposition in the interim?
Yes.
Right. Did you mark out any changes or corrections on an errata sheet?
Howard, I would like to defer to Howard whether or not I had filled out one form regarding my cell phone.
All right. So that's a maybe?
Yes.
And during the course of that deposition, I advised you that if at any time you did not understand my question or you're having difficulty answering it, I asked that you tell me out loud on the record so I can change it to make it easier to answer. Do you recall that?
Yes.
And we agreed that in the event that you did not say anything, we all, judge, jury, all of us could understand you understood the question and are answering it to the best of your abilities. Right?
Yes.
Okay. From 2017 to 2020, basically the time after Maya finally left Johns Hopkins, to the time you left Johns Hopkins, did your position change at all?
No.
Did you continue to work on certain committees?
Yes.
And what were those committees?
Not having the list in front of me.
Best you can do.
Their ethics committee. There was a PICU committee. There, I would have to actually pull up my CV to be able to tell you all of the committees that I was on at that time.
Well, the reason I was asking you is that you said in the first text, I think we're going to talk about, you've been busy with an ethics consult. So I take it that as of the time that Beata Kowalski committed suicide, you were on that ethics committee?
Yes.
The cell phone that we're talking about here, I wanted to read just the last 4 digits. I didn't want to put the whole thing in the record. That's the one that is 9979.
That's not my personal cell phone.
Okay.
I don't
You think
remember.
then that was the hospitals?
Possibly.
Okay.
That's the one that appears next to your, I take to be your statements here in the text. All right. And what number did you send the texts from? And just for clarification, it is the text that began to be discussed today, learned today that Ketamine Girl's mom committed suicide yesterday. And all I'm trying to establish is whose phone was that, yours or the hospital's?
That one was mine.
So one of the statements in this is I've been busy with an ethics consult, so I haven't done anything about orders sets yet. I wanted to find out more about the ethics committee. Was this something where you had calls to, I guess, intervene or to analyze ethical issues?
Yes.
And so what did you do? Not particularly for this one, but in general, when you got a call?
We would take in the information from whoever requested a consult, review the record, talk to all of the parties involved. Then we would convene a subgroup of the committee to have people come and present and to review the records, and involved parties were then excused, and the committee then would discuss recommendations. And then
who else? If there was an outcome, if there was a decision, a recommendation, who did you make a recommendation to?
We would write a formal consult and put it in the chart.
What human being within the hospital, if you had to report to management, who would you report to?
We would fall under the medical executive committee. We also had administrative management that we reported to as well. So, for example, Joe Perno would have been aware of the ethics committee activities.
What was the test to determine whether the ethics committee should consider a case?
We would get the request. We would determine whether or not there was an ethical issue at question. Sometimes it would be more of a legal issue than a ethical issue, or a communication issue. So we would try to address.
Sorry, go ahead.
We would try to address what the specific ethical question was.
To make the cut, so to speak, for committee review, was there any guidelines? Were there any guidelines for you? In other words, I'm assuming you didn't take up matters involving just a disagreement among nurses or social workers or anything like that. Would it be something that would involve a doctor as a requirement?
It would not necessarily have to involve a doctor. It could be anyone was allowed to place a consult or request something to be reviewed. So it could be inter-service related or patient-physician related.
All right. After the time that you learned that Beata Kowalski had committed suicide, was there an ethics committee convened to review what happened?
No.
Why not?
There was no request for one, and we also usually did consults during current hospitalizations if a case involved a patient.
All right. So The committee itself never took it upon itself to bring up a matter. It had to have a complainant.
We did not bring up this case.
Let me try this. How could you decide if something was ethical or unethical if the ethics committee never took it up?
Again, there was no request. If there had been a request to look at it, then it would have been looked at. If a concern had been raised internally or an external person had asked for something to be reviewed.
So the answer is, in that situation, no one would be reviewing the issue. True?
It would be reviewed if someone had requested a review.
Okay. What about in the 3 months of Maya's hospitalization preceding the suicide? Did anyone bring up any ethical issues about her care?
There were no requests for the ethics committee to evaluate the case.
Was there ever any investigation at all of what happened to Maya Kowalski by the ethics committee?
No.
And after Maya's mother committed suicide, was there any investigation into the ethics of how she was treated?
No.
Would you agree with me that using the term ketamine girl is a bit dehumanizing?
It basically sort of is a euphemism to not use her name in a text.
Okay, well, you're not answering my question. In retrospect, wouldn't you say that the term ketamine girl is a bit dehumanizing?
I probably could have used a better choice, but I was trying not to use her name. I'm not aware of that. No.
Can you say, as you sit here today, that you didn't refer to her as Maya in different conversations to other doctors? On the phone, that is.
I'm not aware one way or the other with 100% certainty.
How many ketamine girls were there at All Children's at this time?
Well, I had used that as a euphemism because it was unique and given her history. And
did you ever refer to her as ketamine girl to her name, to her face?
No.
To her mother?
No.
To her father?
No.
So how is ketamine girl not an identifier if MK is the only girl being kept there because of ketamine?
I see it more as an identifier for people that would be familiar with her case, but not something from somebody outside to be able to connect specifically to a person.
You're sure that none of the nurses or social workers or other doctors also refer to her as ketamine girl from time to time?
I have no idea.
All right. You said, sorry to say my prediction was correct. You were predicting you were predicting Beata's suicide, were you not?
Prediction probably was not a good word, but more related on my previous experience of a case during residency. So it may have been more of a speculation than a prediction.
You have a doctorate level education, do you not?
Yes.
All right. So when you say words, you choose what words are appropriate, do you not?
I like to think that I do, but in a text, sometimes you don't think and edit and re-edit, and as a human, you sometimes use words that probably would not be the best words to use.
Okay. So tell us when you say my prediction, please define my prediction, what it was.
I had a previous experience during residency where there was a child who the court had determined was Munchausen's by proxy, and that mother had committed suicide. So it was based on a previous experience.
And where did that happen?
That happened at All Children's.
And when?
I believe it was in my internship year, which would have been 1994 to 1995.
And tell me what the facts were, without mentioning names, obviously, that you believe caused that mother to commit suicide.
I don't have the details. I know as a resident, I believe I might have seen that child one time in the emergency room, and then there was an investigation and she had committed suicide, and that's basically all of the details that I know of that case.
Who were you predicting this to? Who was the recipient of this prediction?
Some of it was my own thoughts, and I believe I had maybe a passing conversation after caring for Maya with a coworker, just saying that I had a previous experience, and that's what had happened.
So by the time Beata committed suicide, you had already gone through one with a mother committing suicide, right?
I knew of one, yes.
Mm-hmm. And you knew the signs of someone who was about to commit suicide from that experience, did you not?
I didn't have any involvement with that patient or family during that period of the investigation and afterwards. I had seen her.
And yet it came immediately to mind when you heard that Beata had taken her own life, did it not?
It came to mind.
All right. And then there is a response, or is this you? I know we did the right thing, but this is really effed up. I feel bad. Is that you, or is that Dr. Tepa Sanchez?
That's Dr. Tepa.
And did you share her concerns that this was effed up?
I shared my concern that I felt bad about the situation.
All right. So you felt bad. And then you expressed this by saying, don't know all the details, but I think the courts and the psychiatrists finally called it what it was. I had another mother do the same thing. We definitely did the right thing for the child. All right, taking this last sentence, we definitely did the right thing for the child. The right thing being what?
That I believe that as a group and an organization that we advocated for Maya, raised concerns, and allowed the process to continue for the appropriate people to look into what was going on in the hopes of having a good medical outcome for Maya.
You do know that Maya did not have a good medical outcome for more than 3 years and still suffers from pain, do you not?
I'm not involved with her care, so I don't know directly what's been going on with Maya.
Did you ever check on Maya to determine whether this statement was correct? We definitely did the right thing for the child.
What do you mean by check on?
Call her, follow up in any way.
No,
Talk
I
to
did
her.
not.
Talk to Dr. Wassenauer, her pediatrician.
No, I had no follow-up contact with Maya.
Did you ever call Dr. Wassenauer to ask him what his feelings were?
No.
And then it says, OMG, that means, oh my God.
Yes.
And then, well, I really hope she has a chance of a better life now. Is that you or is that Dr. Tepa Sanchez?
That's Dr. Tepa.
And did you believe that Maya was better off without her mother?
I think it's sad when any child loses a parent. However, if the investigation was proceeding and found that that was leading to harm for Maya, and that Maya, perhaps Maya now would have a better opportunity to have some other therapies and not be under the high doses of drugs, to be able to succeed at school, to be able to do well.
So you actually believed that Beata Kowalski was doing something harmful to her daughter?
I think that the process of evaluation was underway, and that is that we allowed the system to work, and the people that were appropriate to make those investigations and determinations were involved.
All right. And then it says, well, I really hope she has a better life now. That's, again, Dr. Tepa Sanchez.
Yes.
Do you have any remorse to this day, evidenced by anything in these text messages?
I feel sad about the whole situation, and I feel sad that she chose to take her life. But I'm hopeful that Maya now has been able to be more active and participate in her life and do more things.
Okay. And you saw her feet turned inward towards each other? The dystonia?
I don't recall if I ever examined her feet on night call.
You never saw her feet. Okay. When you saw Maya, though, she was perfectly civil and nice to you, was she not?
She was, she didn't really talk much to me that I recall. She was on her phone the first time I saw her. She was playing on her phone. She did not personally swear at me.
You saw her 10 times, and each time that you saw her, she acted like a 10-year-old, 11-year-old girl, did she not?
Some of the times she was sleeping.
Well, I think 10 and 11-year-old girls sleep occasionally.
Correct.
So, but the point being, your medical records do not reveal any denial of her being in pain. So when you say, let's me see what she does with pain tonight before doing CT, you realized that there was, I don't want to call it a threat, but a possibility that that performing a CT could cause her some discomfort, aggravate the pain, in other words. True?
Yes, there was a potential for that.
So you were the chairman of the ethics committee at this time in 2017, were you not?
Yes.
Still to this day, there has been no retrospective on what happened.
Okay,
Up to the point that I was at All Children's, there's not been an investigation. I cannot testify to what has happened since I left.
Does that complete the plan of the deposition?
Yes, sir.
Okay, members of the jury, I think this is a good time for a morning break. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All right.
Any issues we need, the jury's out of our presence, any issues we need to address before we take a break?
The defense attorney.
Do we have the time breakdown on that deposition?
That was all the plaintiff, Your Honor.
Okay, so can you tell me how long it specifically was?
Yes, Your Honor. It's 23 minutes and 21 seconds.
Okay. Thank you all. We'll be in recess for 10 minutes. Are there any issues we need to?
From a client point of view, I think so.
I believe so, Your Honor.
How long is this next deposition?
Just a moment, Your Honor.
Just as a reminder, at 11:25.
It's 20 to 25 minutes.
It's
again.
22 minutes and 49 seconds.
And who is this all for the plaintiffs? Or is there a
That's
split on
the
this one?
Totality.
I don't recall any defense questions in this one. I think it's all plans.
It was 22 and something?
22 minutes and 49 seconds.
Okay. And who is this?
Dr. Joseph Parno.
Are we ready to bring the jury in?
I believe so.
Yes, Your Honor.
Let's bring in the jury, and you're the new lighting director. Good luck. I'm sorry? Okay, please be seated, everyone. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct?
Correct.
And has anyone approached you about this case since you were last with us? And have you seen any media coverage in the last 20 minutes? Okay. Plaintiff, let's call your next witness.
Dr. Joseph Parno by deposition.
Okay. We're going to try to do the lights again.
Doctor, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Morning, doctor. Please
Morning.
state your name for the record.
Joseph Perno, Perno.
And you are a medical doctor?
Correct.
And where do you work?
Johns Hopkins All Children's Hospital,
And when did you start there?
2003.
Prior to the acquisition of All Children's Hospital by Johns Hopkins?
Correct.
And that occurred in?
2010 or 11.
All right. Is it true that you never actually sat on the risk management committee?
I don't recall attending in 2016 or 2017.
So you weren't there, at least as far as you can remember.
As far as I could remember, I was named a member of the committee as chief of staff, but as chief of staff as a volunteer position, I was still working a full clinical load and couldn't attend every meeting I was invited to.
So as chief of staff, how did you keep up with what was going on there?
Well, as chief of staff, you get invited to every single meeting in the hospital. You pick and choose the ones that are important for the role of the medical staff to attend. And I don't recall ever attending the risk management committee.
But since you were chief of staff, you had, I am assuming, because you're here, some control or management of the risk management committee?
No, I had no role other than to attend and listen what's going on.
Well, how was that information then communicated to you of what happened or what was going to happen?
Is there anything the medical staff need to know about? I'm the liaison to the medical staff. They would communicate with me if there's something that was significant for the medical staff to know.
Well, I understand that, but how about agendas and decisions and topics and referrals up and that type of information? How were you kept abreast of that?
Again, I would only be notified if there was something pertinent that came out of a meeting that they needed addressed with the medical staff. If not, it would
And how would they do that?
probably in a one-on-one meeting. I don't recall anything coming up, but that would be the typical way. Either the VPMA or the president of the hospital would update me.
So let me get this straight. Did you ever see any agendas for the risk management meetings? Any of them?
Not that I recall. If I was on the committee, they were probably sent to me, but I don't recall ever seeing them.
Do you recall ever seeing any one of them, an agenda for a risk management meeting?
Not during that time.
Do you recall receiving any, did you receive any notes, memoranda, or any other documentation, electronic or in writing, of what went on in a particular meeting?
Okay, I honestly do not recall.
During the time that this stay of Maya Kowalski was going on, October 7th through approximately the 14th of January, 2017, were you aware of what was going on with her?
I was, and I think we discussed at a previous deposition, I became aware when there was a question about bringing in an outside physician to the organization.
And was that the only decision that you were involved in insofar as Maya's care?
Correct.
So insofar as being able to answer questions of what went on, what was reviewed, what decisions were made, what recommendations were made at a risk management meeting, you wouldn't know. Correct? All right. So tell me what you knew or understood about Maya Kowalski's care and the situation.
At the time, from what I recall, is they wanted to bring in her personal physician who did not have privileges. And the question was should and how we would give temporary emergency privileges on a case-by-case basis. And as chief of staff, I have a role in that decision-making in conjunction with typically the VPMA of the hospital.
All right. So there is a method to bring in doctors who don't have privileges on an emergency basis. Is that right?
Correct.
What are the criteria?
So they need to be filling a gap that we do not have on the medical staff. So there needs to be a need for them. They need to meet the qualifications of our medical staff to treat the patient. They need to be, for emergency privileges, really they're self-limited to a particular case or time period. I don't have it all in front of me, but it's pretty spelled out by Joint Commission, but those are the main crux of it.
All right, I see two then. They need to fill a gap in an area of medicine that the hospital does not have an expertise in.
Correct.
And then the second one is they have to have qualifications of medical staff. Translate that for me.
Right. They need to be able to be credentialed on our medical staff, meaning they have to meet certain basic things that our medical staff bylaws state you must have.
All right. And so is that in writing anywhere?
Yes.
And what is the name of that document?
That would be the medical staff bylaws.
All right. And so then we had Dr. Hannah. Do you recall Dr. Hannah as being the subject of your review?
Yes.
Let's just assume for the purposes of this question, through other testimony and circumstances, that the hospital was informed that Dr. Hannah could and would be examining Maya Kowalski. What effect would that have on the credentialing process?
I believe it would have no effect. We would still follow our process as a medical staff. It's our job to make sure that people are qualified to treat children, so we would follow the same process. Again, I think it's speculative. I don't recall that we did that, but
he could, and if I'm understanding you, visit the patient as a visitor and converse with her, so long as he doesn't physically examine her or treat her, right?
Yeah, he could visit her as a friend or a colleague, sure.
So if he was turned down at the front desk after applying, or excuse me, even though he didn't apply, but just coming in to see Maya, that would be wrong, would it not?
I don't have any control over security and their policies. We would follow our normal visitor policies at the time, so I can't speak to that.
Well, the patient's rights include to talk with another doctor or specialist at your own request and expense. It would appear then that the patient has a right to speak with another doctor at least. Is that true?
He would be visiting in a role of a friend, not as a physician, because he's not credentialed.
Okay. Well, so you're saying that to talk with another doctor or specialist at your own request and expense, it has to be on the phone?
In the hospital, you must be credentialed to act as a physician. So he could talk to his patient over the phone. He could get emergency privileges and treat her as a physician. But in the building, he needs to be a credentialed part of the medical staff to care for any patient.
Were you aware that there was litigation going on involving Maya Kowalski?
Not at that time.
That is a shelter hearing, shelter proceeding.
I probably knew that she was a shelter hearing, but I probably knew.
All right. Under those circumstances, then, did you nonetheless look at the doctor's background, training, and experience to determine whether he would have been approved?
He never applied or sent it in, so no.
You never did any independent research to determine whether or not?
I would have no need to do that. I've got a lot of duties, as I described earlier. I don't need to be doing extra work.
And as we've established, you can't say whether you were advised or not about that. True? Is that true?
Yeah.
But you have a rough idea of what risk management committee did?
Yes.
What did they do?
They look at trends and different things that pose a risk to the hospital. It's a quarterly meeting, so it's not a real time. It's usually retrospective, looking back what's happened, infection rates, different risks that may be there. Again, and some of this I know just from reading up on it.
Okay. And when you say retrospectively, that means in the preceding quarter?
Yes.
And when you say quarter, are you talking about, for instance, the typical quarters of January, March, June, October?
Yeah, that's what I assume that's the frequency.
Is it true that the board, based on the recommendation of the MEC, can allow someone onto the hospital to make an examination on an emergency basis without submitting their application for privileges?
That is exactly what I was referring to when I talk about emergency privileges. There's a shortened process where we do the basic checks for quality and safety. And yes, it is a recommendation. All medical staff decisions are finalized by the board. But yes, that's the emergency privileging process you're describing.
Sorry, I gotta make a note. Who was there to review what was happening to Maya Kowalski in real time?
So there's no need for a review in real time if the care is going well.
So the answer is no one.
Everyone. We're constantly monitoring our quality of care through multiple indicators, whether it's frontline staff, physician staff, resident staff. We're constantly looking at it. So if there's no red flags, there's no need to do a review of every single case.
What's a red flag?
If there's a concern with the care that we're giving.
Give me some examples.
If there's a concern for inappropriate medication use, prolonged stay in the hospital, discharging too soon, inappropriate floor, meaning need a higher level of care, something along those lines. There's some generalities of things we're always keeping an eye on.
All right, let me ask you about some different things and ask you whether they would meet the threshold for the risk management committee, and we'll work through the other ones. A patient such as Maya Kowalski being kept by the hospital against her and her parents' will for 7 days. Would that reach the threshold of something that would be reviewed by risk management?
And no, I mean, risk management committee meets quarterly, so that would not be appropriate.
So would it be reviewed retrospectively?
I do not know.
Would it be reviewed by the patient safety committee?
Probably not.
Would it be reviewed by the standards and credentialing committee?
Definitely not.
Can you think of any other committees that might review a patient being kept against their will at the hospital?
I don't believe we keep patients against their will, but it would probably be more of a team meeting with the care team and the family to discuss best process.
All right. The patient being prohibited from seeing her priest, would that meet the threshold for the risk management committee?
again, the risk management committee doesn't function in real-time decisions. It's a quarterly meeting.
Well, then who at the hospital checks to make sure that the floor staff, the doctors that are actually involved, are doing the right thing?
So we have risk managers who are involved on a day-to-day basis that will interact with the staff as necessary. We have social workers for scenarios that you're kind of leading towards that would work together with the care team to make sure we're giving the highest quality care.
What if it's the social worker who's actually doing the things that are highly questionable, if not illegal?
We have physicians, we have risk managers would be involved, and I would like to say our social workers don't perform illegal activities.
Who makes the decisions or oversees decisions about compliance with court orders?
I would say that's probably our risk management department.
So in terms of, let's just say there are facts in the record that Maya Kowalski's priest was prohibited from seeing her in the hospital. You would agree that that violates Maya Kowalski's rights?
I wouldn't necessarily agree to that, and I don't know why the priest was denied, but I wouldn't agree to that.
Okay, so who was there then to review the actions of a nurse or a doctor or a social worker who came up with something like that out of their own head? Who was the next level to check to see whether that was appropriate standard of care?
It would be probably a team decision between the caregivers, the social work, the nursing staff, and again, likely risk management in this scenario.
And who's the superior to risk management?
I don't know. I would guess our legal counsel, but I don't know. I'm not in that.
And who does your legal counsel report to?
At that time, it was the president.
And other than the board of directors, was the president the highest authority at the hospital?
Yes, the president at the hospital, yes.
Let's ask about the child being stripped down to her underwear, short shorts, against her will, and photographs being taken of her without any court authorization, any authorization or notice to the parents, and against both the parents and the child's will. Would that be the type of thing that would meet the risk management threshold?
No, because I would consider that part of our standard care and treatment plan. We often will take pictures of patients to document for the medical record.
Make sure I get this right. Standard of care. So, Johns Hopkins All Children's Hospital, standard of care could include stripping a child down to her underwear and photographing her in a private room against the child's will, against the parents' will, and without notice to the parents, and without any court order or legal authority to do so. Am I correct in that?
I think the legal authority is the consent to treat. It's part of a treatment protocol. Many children object to things we do for them, right? If I'm suturing a child in the ER, they object. If we put an IV in their arm, they object. So a child's objection, I think, is difficult. We work with them. But yeah, it's taking non-patient identifiable pictures to help with the medical record, whether it's bruising, whether it's rashes, whether it's injury. It helps enhance the medical record. So it's part of a standard treatment plan.
But in every one of those circumstances, the parents are notified and give their consent. True.
We have consent to treat. So once they give us consent to treat and examine, that's all part of a physical exam and treatment plan. So yeah, that consent had been already given.
Well, can the doctors put a child into a surveillance room for 48 hours
under false pretenses of testing without parent consent?
Yeah, I think we choose rooms for our families all the time without consenting families. And if we feel it's part of the treatment plan, I don't see that as a separate call out either.
What possible benefit to the child is it to put them in a room where they cannot reach the commode for 48 hours, knowing the child cannot walk, and keeping her in that darkened room for that length of time?
Are you asking about this specific patient? I can't speak about this specific patient. And I'm not sure exactly what you're trying to get at.
When is Baltimore consulted in terms of standard of care?
Very rarely. And in 2016, probably never.
But the point is, Johns Hopkins in Baltimore was not monitoring the level of care that you were providing down here. True?
Correct.
And they were not influencing it anyway, correct?
Correct.
Are you aware from any source other than your attorney that Beata Kowalski committed suicide?
No.
So to this day, sitting here, you're not aware that Beata Kowalski killed herself and left suicide notes which blamed Johns Hopkins' level of care. Are you aware or not? Are you aware?
I have no knowledge from outside sources.
Okay. Did you ever speak with any of the physicians that were involved in Maya Kowalski's care while she was there or soon after?
Just in regards to what we discussed with the potentially bringing in an outside physician.
Okay. So in that limited conversation, then I take it that you never learned that there were texts back and forth predicting Beata's suicide, right?
I have no knowledge of that.
And you would agree with me, though, that if a Johns Hopkins physician is aware that a patient or visiting parent is a suicide risk, that is something that risk management should consider.
Yes.
It's kind of an abrupt end, but that's the end.
Okay. Are we gonna have another deposition or?
We do.
I'm sorry?
Yes, we do.
So I'll leave the lights as is. And your next,
The next deposition is Dr. Anthony Napolitano.
hold on one second. I'm sorry? If there's a question, go ahead and write it out. And Mr. Whitney, while the jurors writing out, from a timing perspective, are we okay with the next deposition?
I think you said the breaking point is 11:30, is that right?
11:25.
It will be fine.
Doctor, would you raise your right hand for me, please?
Hold on a second.
So, they have some questions. Apologize. All right. Looks like there are a lot more. Are there other questions? I'm sorry.
Okay, members of the jury, one of your number had a couple of questions. Obviously, with a deposition, I don't have a live witness here that can answer that. But as you've seen, the attorneys are very aware of the questions that were raised, and I suspect they will address it in due course. And let's proceed with the playing. Hey, is the lights okay? Do we need to dim it down some more? Okay, thank you.
Doctor, would you raise your hand for me, please? Do you swear affirm testimony you're about to give the truth, whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
Anthony Napolitano.
Dr. Napolitano, do you understand that you are appearing pursuant to a directive by the court that the defendants produce someone with knowledge regarding the Risk Management Committee operations and issues regarding the chain of command and control?
Yes.
And have you ever served on the Risk Management Committee?
Yes.
What years?
I would say 2014 through 2019.
And what was your position, if any?
I served as chair of the Department of Pediatrics.
Who else in 2016 was on the committee with you?
There would be the chair of the Department of Surgery and members of the risk management team.
You're real soft. Can you speak up a little bit on this?
Sure. It would be Dr. Columbani, the chair of pediatric surgery, and members of the risk management team.
And who is that at that time?
I don't remember all the names. It would be Jackie Crane would be the name I remember.
And she was the general counsel?
I believe she was.
Can you tell this jury, from the best of your memory, whether the Risk Management Committee of Johns Hopkins All Children's Hospital ever took corrective action in any way about Maya Kowalski's considerations and situation?
Not that I'm aware. Not that I am aware.
How does risk management manage risk in real time?
We go back to our divisions and our care areas and look to see how we can help.
So you do or do not discuss things happening in real time?
No.
No, you do not.
We do not discuss real time.
So if a physician or a group of younger physicians makes a mistake, to the best of your knowledge, there's no one at the hospital that is there to correct them in real time.
It's not in real time.
There's no one there that was reviewing what the hospital was doing in real time, correct?
In real time, no.
So, for instance, if you had a social worker who was acting inappropriately towards a child patient, there was no mechanism by which risk management would intervene and try to stop that behavior. True?
No.
Did you know anything about, Doctor, did you know anything about what happened with Maya Kowalski?
I read about it. I read the article about 2 weeks ago.
But before that, as a member of the Risk Management Committee, you'd heard nothing?
I had heard nothing about the case.
And what other positions did you hold during 2016, 2017? What other committees and things were you on?
The Department of Medicine.
What was your position?
I was chair of the Department of Medicine, pediatric medicine.
And in that capacity, you didn't hear anything about Maya Kowalski?
No.
All right. What else were you on? What other committees and organizations were you on?
I would sit on medical executive committee.
And as a member of the medical executive committee, you didn't hear anything about Maya Kowalski?
No.
To the best of your knowledge, did anyone from the quality department, such as a vice president of quality, report to the medical executive committee about Maya Kowalski?
No.
Do you have any idea why you, as the chief Department of Medicine chair, would not know about a child being kept at the hospital for this long, or 3 months, involving court orders and an eventual suicide of the mother?
The care is managed at the division level.
Managed at the what?
The care is managed at the division or the treating doctor level with their care. It doesn't come up to me. I would not hear day-to-day operations or care like this.
What remedies were available to the patient, most likely the patient's parents, if the doctors at the treating doctor level were misdiagnosing or otherwise negligent in their care of the patient?
Object to form.
They would ask to speak with the division chief and ask to sit down and speak with him or her to discuss the concerns they had.
All right. And with Maya Kowalski, they're under allegations of child abuse. Who would that fall under as a division chief?
That would, for the care or for the care patient?
Yes.
That would be the division chief of hospitalist medicine.
So I know you didn't learn of it till recently, but you do know Maya was there under a court order, correct?
My knowledge is really from what I know from reading the USA Today article that I read.
Okay. And who was responsible then for assuring Maya's care was aligned or complied with a court order?
That would be the physicians caring for Maya.
And if the physicians were not monitoring the nurses and errors were made in her care, how would that be corrected so the child was no longer injured, hurt, or troubled?
It would be the nursing manager of the floor that Maya was on.
As chair of pediatric medicine, do the hospitalists belong to your department, pediatric medicine?
They're one of several divisions, yes.
The ones that what?
Yes, they would. The hospitalists fall under the Department of Medicine.
All right. And so during 2016, who were some of the hospitalists that were under your authority, if you will?
At that point in time, And this is reading from the article, would be, I think, Dr. Deese. It's one that I read, and
Who was it? Sorry.
Dr. Deese.
Okay. Anyone else? Dr. Major?
She would be a hospitalist, yes.
Let's see, how about Dr. Young?
Dr. Young, yes.
Dr. Carroll?
Yes.
Dr. Davidson? Danielson, excuse me. I'm sorry, Danielson.
The first name on Danielson is who?
Kristen?
Would be a hospitalist, yes.
So she'd be under your care, or your
under
authority. Okay. And throughout this period of time in the fall of 2016, did any of your hospitalists that we've mentioned here ever come to you with any concerns about the actions of any fellow doctors, nurses, or social workers?
No.
If they had come to you and said, the patient's complaining that she's being tortured every time she has to do this type of physical therapy, what would be the procedure? That's an example. What would be the procedure then once you receive that report?
I would speak to the division chief to understand what was happening, ask for a report on what's happening.
Well, who is the division chief for that? What division are we talking about?
The hospitalist.
Well, who was the division chief in 2016 while all this was going down?
I don't remember. I have to go back. We'd have to go back and look.
To the best of your knowledge, has Johns Hopkins All Children's Hospital done anything to change the way it operates since Beata Kowalski's death, Maya's stay there?
No.
In fact, most of the doctors, nurses, and staff like you don't even know what went down, do you?
From the article that I read is how I know about it.
But internally, coming from within the hospital, nobody ever brought to your attention what happened there. Is that right?
No.
Okay. And who was there to make sure that the patient's rights, as stated in this particular document, the guide for patients and families, who was there to make sure that the patient's rights under that were being upheld, honored, if you will?
The local leadership, the managers of the unit, the nursing managers of the unit, and the physician, the division chief.
Well, you just testified now that you don't treat adults. Who there is qualified to diagnose a parent as having a mental illness?
We don't have adult providers at the hospital, so we really do not manage adult care.
I take it the answer to your question is there isn't anyone there that is qualified to diagnose adult psychiatric issues.
Yes.
And that was true in 2016, correct?
Yes.
Be the end.
That's it?
Then we announced the date. It's a bit hard to read on that deposition.
No, it's still going.
It's still going.
Oh, it is.
All right.
Sorry.
So
Long break.
I'm going to ask you now about some allegations you haven't heard from your testimony other than popular media, and ask you whether these comply with hospital policy. Maya's priest was prevented from seeing her. Does that comply with hospital policy?
I'm not aware.
Okay. She was prevented from having a computer or any electronic devices. Is that part of the hospital's policy generally with children? Not being allowed to have any food, any baked goods from parents or even her little friends. Is that hospital policy?
If a patient was on a specific diet, potentially.
To strip her to her underwear, short shorts, and physically hold her down to photograph her. Is that part of the hospital policy?
I'm unaware.
All right. What about listening in on calls with her lawyer? Is that hospital policy?
I'm unaware.
Do you report to anyone in Baltimore?
No.
Have you ever?
No.
Is it true that the hospital, All Children's, continue to operate with essentially the same staff and same procedures and same level of care after Johns Hopkins bought it as before Johns Hopkins bought it?
Yes.
If there's a truly egregious event at the hospital, and I assume there has to have been some over your tenure, what is the most direct line to the president?
I'd go to the president of Johns Hopkins All Children's.
Okay. Do all department heads have access directly to the president?
At that point in time, in
Yes.
2016?
Yes.
Yes.
Okay. So what divisions are part of your department?
At that time?
Sure.
So it would be the cardiology, hematology, oncology, critical care, hospitalist medicine, genetics, infectious disease, neurology, rheumatology.
Well, if you had, then you would have had control over all of the doctors we mentioned from one department or the other, would you not?
I'd have a good deal on the medical side.
All right. And then how often would you have a meeting in 2016 with the heads of the departments?
We try to meet monthly. Not everybody would attend, but we try to meet monthly.
And in terms of the discussions, do you recall any discussions, even in the general terms, about a child that was being held by court order in the hospital for a long period of time?
No, that would not come up in the division meeting.
How many times have you ever heard of a child being kept at your hospital for over 3 months against their will?
I'm not aware of that.
And so still, if that in fact is true, that that was the circumstance, Maya was being held for over 3 months against her will and her parents' will at the hospital, that was not a significant enough event for any of the department heads to bring up
No,
I see. So it doesn't really matter if the child feels that they're a prisoner, the patients feel the child is a prisoner. You're going to stick to your, what did you call it? Methods of care?
yes,
I don't think I'm premature this time.
And this was from May 11th, 2023?
Yes, Your Honor.
Okay. Can I see the attorneys for a moment? We're going to go ahead and take lunch now. And this is one of a meeting that was pre-planned that I had, so it's the fault's on me. I'm going to ask Deputy Coley if you could have them back ready to go at 1 p.m. We've got a full afternoon, so please be ready for a full afternoon. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And we'll see you back at 1 p.m.
All right, first exiting.
Okay, thank you. Everyone, please be seated. So everyone knows we will be back at 12:15. Now, I do have another 12 or 13 minutes if you want to just start, or do you want to just take lunch now?
Judge. I'm happy to do that.
Yeah, because I've got about 12 or 13 minutes. And
The time on that last deposition, Your Honor, was 19 minutes and 34 seconds.
That was just the one about Dr. Perno. I don't think,
I'm sorry?
did they give the time on Dr. Perno? I didn't think so.
It was 22 and like 40 something seconds.
Yes.
Okay.
And the one before that was 23 and 21 seconds.
Sorry.
Okay. So I've got my list. No, we'll just start and then we'll pick it back up at 12:15.
You do have one motion you'd like to have heard before the afternoon witness, Your Honor.
You want to go ahead and do that one right now?
Me, Judge. Maybe longer than 10 minutes.
If it's going to be longer than 10 minutes, we probably.
Okay.
Well, what's the motion?
It's a motion to limit or exclude Dr. Corcoran's testimony.
Oh, we haven't seen that.
Got filed 2 days ago.
Well, perhaps they can look at it over lunch and then be ready to talk about it. So I guess it's back to you, Mr. Whitney, about exhibits.
Thank you. I'm going to start on the back page of the exhibit list we provided. And again, this is under the risk management file, which is exhibit 2277. And I'd like to focus on pages 630 to 631. You can pull up 2277 to 631. Your Honor, the email on the bottom half of the page was previously admitted with redactions.
Oh, yeah.
But we would, so we could redact the entirety of that from this email if necessary. But we would like to admit the top email from New Year's Eve with redactions, of course.
So when you say the top one, are you talking about the one at 219, talking about a transfer? Or the one?
Yes, I'm sorry. Those two. That starting with that one, which is 2 lines, and then up to the top, that exchange.
Judge, sorry, I'll wait for court to stop reading.
Okay, and what was the status of the court order? It said, if I remember correctly, at this time, it allowed Johns Hopkins to supervise the call specifically.
That's correct.
Within its.
Judge, this is clearly all started with DCL.
Well,
it includes counsel referring to counsel. It's going to get further entrenched into the DCF hearings.
Your Honor, the relevance of this email is that Johns Hopkins has repeatedly taken the position that they were doing everything they could to transfer this child out of there. And that's the nature of the 2 lines at 2:19 p.m. It has nothing to do with, it's a medical transfer, it has nothing to do with a court order. And the top email, the first line of that email reveals the type of attitude that was being expressed to other facilities about the potential transfer. So it's relevant and necessary for us to push back on the idea that they were doing what they could to accept transfer.
Anything else, Ms. Quarles?
I just disagree with their aspersions and characterization of the email. They're trying to interpret, and presuming they're going to try to interpret for the court, what it means is not yet once they get wind of issues with the family. I mean, that's having to do with the dependency court.
Hey, this is what we're going to do now. The bottom email, the one at 6:12 p.m., either you need to redact it in its entirety or redact it consistent with how we previously redacted the predecessor email.
Understood.
The one at 2:19 that starts with thanks for the update, that entirety, those two sentences or those three sentences will be unredacted. Those will come in.
I'm sorry, I'm not
redaction.
following. Oh, there. Okay.
And up at the top, the first line, which is three sentences, that will remain in.
And the remainder redacted.
Well, the answer is almost yes, but this concept about Maya's recent scratches self-inflicted, that isn't dependency related.
Right.
I think the sentence, plus we are exercising our right to listen in on the calls the best we can due to Maya's recent scratches self-inflicted, can stay in, because we're going to have an instruction that tells them as of this date that there was authority for Johns Hopkins to supervise the calls.
May I read that sentence to you, Judge? Mother shall have, and I'm sorry, I didn't. May I?
It's just a sentence.
Number 2 of the order.
No, it's the sentence, plus we are exercising our right to listen in on the calls the best we can due to Maya's recent scratches self-inflicted. That sentence would remain in.
Okay.
Who's taking notes as to?
I've got the notes. I have the email here and I have the notes on the redactions. I will make it happen over lunch.
Anything else about this email?
I'm not, did you redact the rest? I wasn't
Okay,
sure.
the only thing that's coming in on that very top email, the 739 email.
Can we have
is
it
the-
large again?
And Mr. Ray, thank you, is the very first line, which comprises three sentences, the one that starts not yet once. That whole line stays in. And then the only other sentence that will remain in is the sentence that says, plus we are exercising our right to listen in on the calls the best we can due to Maya's recent scratches self-inflicted. Everything else will be redacted.
Your Honor, this is a bit nitpicky, but the two signatures that just say sent from my iPhone, I would keep those.
Can you scroll it down so I can see what it says?
Just says at the bottom of the screen here, sent from my iPhone.
That's fine. That's not dependency court related.
Okay, thank you.
And then, of course, the next email in that chain, the 219 email, will stay in. And then the email below that.
We will redact consistent with the previous rule.
Exactly. And so when you tender the redacted version, this will be called 2277-630A and 631A. And so the court will receive the A version as redacted.
Judge, I just like to reiterate our objection. We're going deeper and deeper down the DCF and dependency rabbit hole.
I don't think so, Mr.
Particularly in
Hunter.
light of the last two depositions and the court's rulings on our objection. So I feel constrained to put that on the record, Judge. We're parsing a course that can't be parsed. And I just have to object here.
And I appreciate it. And let me just give you my rationale, and then I've got to run. There are obviously causes of action that I have not allowed in because of Chapter 39 immunity. I don't have that order in front of me. I don't have the buzzwords in front of me. But it was, anything that was as a consequence of the call, and the actual dependency hearing is, obviously a consequence of the call. And I think I've been very clear about that. But there are other counts, including the medical malpractice, because Maya was a patient at Johns Hopkins All Children's Hospital concurrent to the time of the dependency court action. And there's also other counts, including the outrage count, negligent infliction of emotional distress, plus others. And so there is evidence that could be down the dependency court, but also is relevant to the other causes of action. And what I have been attempting to do is, wherever I can, to excise out anything that is purely dependency court. But if it's something that goes to a medical malpractice or one of the other counts in this case, even if it specifically or somehow references the dependency action, I'm leaving it in, because the jury already knows about the existence of the dependency action. They're going to be instructed, and we've already somewhat instructed them, that the hospital is not responsible for Maya Kowalski being there and could not discharge her against a court order. So I don't believe that the evidence that has been coming in is improper, given the causes of action that are actually pled that are outside of the Chapter 30 member immunity. And with that, Mr. Altenburn, you get 15 seconds. And then
that's all I need. I just got to say, I need to review. We've been doing the objections in your rulings on the depositions in this kind of the wholesale fashion, so I don't get to see all of this. But there was a massive amount of information in Dr. Politano's deposition about being held prisoner and this and that and the other thing. And keeping in mind that count 14 is only a negligent training count, there was things way beyond that. And then we're talking about things that appear to be going to punitive damages that are after the fact conduct. None of that is admissible for punitive damages. So there's just a pile of things that got in that deposition that, Your Honor, I respectfully think are error.
Well, I appreciate that. Assuming that those questions were designated as objectionable.
Yeah.
Yes.
And that's what I want to say.
Some of them were, but then there were some of them in there that didn't, that sounded to me like I don't remember reading any of that. So I think some of what you're talking about wasn't actually designated. But I mean, I've been trying to rule the way I just articulated it just a moment ago. I mean, that's what I did last night with Dr. Is it Newberger? I mean, I sustained a whole bunch, but I let in some stuff. I cut pieces and, look, I'm doing everything I can to be fair to both sides with the causes of action that are allowed, those that are not allowed, and that's the way I'm going to continue to roll on it.
Certainly before Dr. Corcoran's testimony, I filed a motion, I think on Sunday, trying to limit some things as to relevance because of these things, and we haven't really been able to hear that.
Well, I think that's what Mr. Hunter said, and I said that we were going to need to do it, and I really need to,
yes, I know. Yes,
to go. Judge Moreland is on time all the time. Bye now.
Otherwise, for the reason.
We're going to address, folks.
Judge, it'd be the motion to limit Dr. Corcoran's testimony that we made reference to before the break.
And at some point again, Judge, if you've had the chance to review it, though, Williams' motion, you have to find out about those.
Well, Mr. Hunter has the floor right now.
Thank you, Your Honor. May it please the court. We've made a motion to limit or exclude the testimony of Dr. Joseph Corcoran. The basis of the motion main thrust of the motion is exclusion, and it is based on section 766.102, paren 7 of Florida statutes. As Your Honor has heard before in this matter, section 766.102 provides for the qualifications under which testimony may be offered by an expert witness in a medical malpractice case. A threshold requirement is that the expert witness have reviewed under subsection 5 of the statute all pertinent medical records, which this witness has testified he has not done. Above and beyond that, however, and more importantly, the thrust of this motion, under section 766.102, paren 7, anyone who is testifying in a medical negligence action against a hospital or healthcare facility may give expert testimony on the appropriate standard of care or other non-clinical issues administratively if he has substantial knowledge by virtue of his or her training or experience concerning the standard of care among hospitals of the same type as the healthcare facility or hospital whose acts or omissions are the subject of the testimony and which are located in the same or similar medical communities. Now, I paraphrased the statute there, Judge, but the thrust of the statute is that the threshold substantively for the competence of an expert to testify on administrative and non-clinical matters against a hospital is the question of whether they have substantial knowledge and experience in the same type of hospital. This witness has never practiced in a children's hospital outside of medical school over 30 years ago. He has never been a CMO of a children's hospital. His experience as a CMO or senior executive official in a hospital setting comes as a result of having served as a CMO, chief medical officer, in a general hospital, not a children's hospital, a general hospital of a different type in a different medical community than All Children's Hospital in St. Petersburg.
He's in the room during your argument.
We asked the doctor to be excused.
Dr. Corcoran, if you could wait outside, please.
In any event, Judge, that's the thrust of the argument. The record has established through his deposition testimony that he's not familiar with the different levels of licensure under Florida statutes for different types of hospitals. He is not familiar with the differences in specialty as opposed to non-specialty institutions. He has no familiarity with the disease processes here at issue among pediatric patients. In fact, he's testified he's not a pediatrician. He's never been a pediatrician. He has no knowledge of the diagnosis and treatment of CRPS, the use of ketamine, or any of the other clinical issues that are at issue here. He is, by training, a osteopathic, board-certified OBGYN with no pediatric credentials whatsoever, who has never practiced significantly in a pediatric hospital.
Do pediatric hospitals use a different coding system than other hospitals?
Coding system in what respect?
For billing purposes.
I'm not aware that they are, but on the other hand, he's never been provided their billing records.
Yes, yep, he sure has.
Okay. Anything else, Mr.
Not
Humphrey?
according to his deposition. That's what we have, Judge, and the alternative part of the motion is that his testimony be limited to those matters with respect to which he can furnish familiarity. If Your Honor is suggesting that perhaps if he's properly informed regarding billing, that would be a potential exception. But as a matter of standard
When was this deposition taken of Dr. Corcoran?
Deposition was taken, Dr. Corcoran, sometime recently.
August
Judge.
1st, 2023.
He was the one that, Your Honor, let them add late at the last minute. It was taken you said August, that's probably, yeah, that sounds right.
August what?
August 1st.
And so this motion is coming in
We
on.
can get the transcript before the deadline day.
Transcripts can be had in a day or two. I'm just wondering why, because we had so many of these hearings before trial. Why, when we are with lots of people here and people ready to go to testify, that we're having this conversation now as opposed to, the day or the week before trial even started? Why wasn't it filed by then?
Judge, we thought we would file it at a point where we had a complete picture of what he had reviewed, and we had the opportunity to put it together. And
But if the deposition was on August 1st.
I'm sorry?
I said if the deposition was on August 1st, why wait 2 months to file the motion? The reality is you want me to make a decision, which these motions take a lot longer than the snap amount of time that I'm being given on this.
Judge, in years past, we would make this motion after voir diring the witness at the time on the witness stand.
I don't know, how many motions in limine to exclude various doctors and opinions have we had
We
in
had,
this case?
Judge, we had a number of them. We had a number of those in June, July, and others in August. This doctor got deposed late. He never got a report to us till very late. And
His report was timely on June 10th, 2023.
I'm going to hear from your side in a moment. I don't know what to do, Mr. Hunter, because I feel like I'm being jammed on this. I mean, he's here, everyone's waiting, and you're asking me to make really substantive, substantial rulings on things that I would have liked to have actually had some time to think about and to, read it in more detail.
Judge, I regret making you feel that way. That's not my intention. There's a number of us getting jammed about a number of things in this matter.
Mr. Whitney, what's on your side?
The relevant section of the statute is 766.
Well, first off, tell me what this doctor is going to be testifying to. Let's start fundamentally.
Well, that's probably better Mr. Anderson's question.
He is a hospital administration expert, Your Honor. He has analyzed the rules, procedures, routines, forms, releases, and the internal documents of Johns Hopkins All Children's Hospital. He is offering opinions about the failure of the systems within the hospital to prevent many of the situations that happened here, including Kathy Beatty and treatment of Maya Kowalski and the overall treatment of her through her stay. He is opining as to whether the hospital had sufficient control to advertise itself as Johns Hopkins All Children's Hospital, given the fact, as just testified to by, I believe, either Dr. Perno or Napolitano, that there's absolutely no control whatsoever over them by the Baltimore company. He's also testifying about the lack of training in the first part. In the second part, she probably shouldn't have even been anywhere near Maya Kowalski in light of the memo regarding aggressive behavior and the extent to which the aggressive behavior was known and how unusual it is for the type of report that was filed against Ms. Beatty to be in a hospital, and the fact of threats of physical violence by one employee upon another are a very grave allegation in a hospital, particularly a pediatric hospital. He will testify, and thus that Ms. Beatty should have been sent back if they wanted to keep her for significant training, which they failed to do, or she should have been released, or at the very least, she should not have been put in to be whatever you want to call her towards Maya Kowalski with very little control. He's going to testify to what you heard from Dr. Perno and Dr. Napolitano, the fact that there was absolutely no real-time review or risk management of events as they happened or within close proximity of them happening sufficient to put a halt to things that were ongoing. He will testify to this was a fox guarding the hen house situation because of the way that Johns Hopkins has set up its monitoring system such that you had people who worked together all the time, if not totally, were counted on to report about each other in the event there was any violation of Johns Hopkins internal rules. He'll testify concerning the internal policies and procedures of Johns Hopkins All Children's Hospital. Instances include their elopement routine, their 2 or 3, their minor leaving AMA routine, their failure to express the patient and family rights and comply with them in the handling of the Kowalskis. That is a summary of his testimony, and it is set forth not only in his deposition, but in his report. Let me find the date of the report. It was filed timely, as co-counsel has stated, but he filed that, and he also filed, the court may recall, an affidavit, I believe, in support of punitive damages, in which he went over many of these points, I think almost all of these points, and that affidavit is April 12th, 2023, prior to one of the final motions on that. So the defense has had an opportunity to receive a report, an affidavit, and depose him extensively, at which point he covered these issues. All of the things he's testifying to are in evidence.
If you need further on the statutory argument, please let me know.
I'm still trying to read, and that's why I say I got jammed on this one. I don't know how you want me to do a quality job at making well thought out decisions without giving me the time to do it. I mean, I can make rulings, but I like trying to think through what's being requested of me, get a chance to actually read the depositions, and I'm still trying to read his report right this second.
Judge, I appreciate that. Some of the stuff that you're hearing is clearly outside of the pleadings that have been put forward. Count 11, for example, has been walked away, walked back. He's being put forward as an all-purpose expert regarding a very limited specialty hospital, and that, I suppose, is the point. And I apologize, but I didn't perceive that as being a matter that required that much forethought. And if that's my bad, that's my bad.
Well, if you're making the argument that he has never been the chief administrative officer of a specific children's hospital, and you're contending that that is the requirement under sub 7 of the statute for him to be qualified, is that the argument you're making?
Yes, sir. I'm making the argument that someone who's going to criticize the standard of care of a specialty hospital under the statute needs to have substantial knowledge and experience demonstrated of their ability to know and be familiar with the standard of care for the same hospital. That's the clear black letter law of the statute.
What do the cases say interpreting the statute? Since
There's very few cases that interpret this statute as opposed to the statute under 766.102(5).
No.
But under 102(5), the cases are very clear that it's got to be that the expert witness against or for whom a witness is testifying has to be in the same specialty. This requirement is essentially the same thing as applied to hospitals.
Your Honor, subsection 7 begins, notwithstanding subsection 5.
Considering that I wasn't given the opportunity really to think about this or review, can someone give me a case interpreting the statute so I can actually see what courts have said about this statute?
The primary case they cited, the only case they cited, is Santa Lucia versus Levine at 198 Southern 3rd 803. And that case does not discuss the relevant statute. It doesn't even discuss 766.102. It discusses a separate part of the statute under 766.103. So we don't yet have a case.
There are actually two cases we cited, Judge. Neither one of them construes this particular subsection of the statute. That's why I said what I said a moment ago. The point, however, is that under this statute, which was amended in 2013 to require it tightened the similar healthcare provider requirement for giving expert testimony and required expressly that you have to have an orthopedic surgeon, for example, to testify against an orthopedic surgeon.
What was the law number?
I'm sorry?
What was the law number that was the change? I mean, these are things that I would normally have done so I can actually understand what the legislature has done.
The Laws of Florida citations was 2013-108 and 2011-233. And I believe the latter one in 2013 is the one that tightened the similar healthcare provider provisions, subsection 5.
Your Honor, if I may.
So 213-108 Laws of Florida. Doesn't say what you said it says. So what's the next one?
2011. Sorry.
I don't know what to do, Mr. Hunter. I don't feel like I am ready to make a decision on this issue. I feel this is way too late. I mean, if just looking at the statute, what you're saying is because he has never been a pediatric hospital administrator, he is not eligible to qualify under the statute. I think you're probably reading the statute a little too narrowly, but again, I haven't had a chance to do it. So if I have to make an on-the-fly decision, I'm going to overrule that because you haven't shown me any case law that would construe it that way or And if I got to make a decision without any chance of reflection, then I'm going to say no.
Judge, I would simply point out to you that the plain language of the statute requires substantial knowledge and experience with respect to the same type of hospital. That's the purpose of the statute, as obvious on its face. That's the objection we were making.
Well, I don't
We can
believe
make
the
that
word
objection.
same is in the statute.
I'm sorry?
No.
Your Honor, it does say of the same type as the hospital in subsection 7. I wanted to clarify the factual point, which is that
Same or similar communities, and he was the head of what, Brandon?
he was the head of Brandon, correct?
It's all part of
Which
Tampa
had-
Bay.
He was the chief medical officer of Brandon Hospital, which has a pediatric hospital within it. And in fact, he affiliated and collaborated with Johns Hopkins All Children's Hospital in establishing the standard of care at Brandon.
Is that true?
Not to my knowledge. He certainly didn't say that in his deposition. He did testify in his deposition that at Brandon, his hospital, not him, he didn't service the contract, his hospital hired pediatric ER doctors and pediatric neonatal intensivists to come in and run portions of their hospital. But he also said that he had nothing to do with either making or servicing those contracts. So I don't construe that as assisting them in making the standard of care. If Your Honor will look at the statute, it's a matter of his having knowledge and experience in the same type of hospital and in a similar community. It's a two-pronged test. Now, the similar community is wishy-washy here, but the same type of
Says
hospital
or.
is clear. I'm sorry?
It says or, right? Not and, it says or.
It says the subject testimony and which are located in the same or similar communities at the time of the alleged act giving rise to the cause of action.
And if you're suggesting that Hillsborough County and Pinellas County are not the same or substantially the same.
No, sir, I'm not suggesting that. I'm saying that what I'm suggesting is that the same type of hospital is the primary standard here. And he has not demonstrated that level of knowledge. This would.
So you agree it's the same community?
Yes, sir.
Okay, so you're only talking about.
Same type of hospital. And Judge, with all due respect, this objection would be perfectly appropriate at the time he offered the opinion.
Except that the court said prior deadline.
Just focusing for a moment on the or that the court points out, same or similar communities, in addition to being the chief medical officer of Brandon and Pediatric Hospital there, and affiliated with Johns Hopkins in those efforts. He was also the division chief medical officer for HCA Far West Division, and he oversaw Sunrise Children's Hospital in Las Vegas. So Las Vegas and Tampa are substantially similar.
Through the league.
Well, they both have football teams. Both had John Gruden as a coach.
I would suggest to you that they're the similarity then, Your Honor.
No, I. Where else has this doctor been? Remind me.
Hospital Corporation of America.
Yeah, he's been an executive with HCA Hospital Corporation of America. In that role that I just mentioned, he was the division chief medical officer. I think he'll say he oversaw 10 hospitals in that role. And the one I mentioned was Sunrise Children's Hospital.
It's Hospital Corporation of America, the largest hospital.
I know what HCA is. Mr. Hunter, what I'm hearing is, from a factual standpoint, he may qualify even under your definition. That's about the best I can give you right now, given that I wasn't given time to prepare for this. Mr. Altenberg?
Yeah, if I may, beyond his qualifications, I'm going to be instructing my trial guys to object a lot because of the scope of the pleadings. There is no risk management claim under 766.166 expressly in count 8. Nothing in there alleged a management thing. It was diagnosis and having a treatment plan is what's in count 8. In count 14, the smorgasbord is now down to a negligent training claim only. And it only references 766.166 for the paragraph, I believe it's 170, to say it's sort of like this. And so I was listening to opinions that might have been appropriate when count 11 was in, but count 11 was voluntarily dismissed. So anything about the training or the not the training, but the background on Miss Beatty and whether she was disciplined in the past is not relevant to this.
Your Honor, as you're aware, we
Excuse me.
Yeah, let Mr. Altenburn finish,
I
please.
thought he was done.
At any rate, we need to keep this within the scope of the pleadings. And it sounded from what I heard, numerous things were going beyond anything that is left at count 14, and there's no risk management claim pled in count 8, except by incorporating that which is in count 14.
Are you done?
Yes.
All right.
Hold on a second. So, Mr. Whitney, you're telling me that Dr. Corcoran, when he was administrator with HCA, had under his constellation of hospitals a pediatric hospital?
Yes, Your Honor. And as CMO of Granite Regional Pediatric Hospital within it.
Now, how about Mr. Altenburn's point about the scope of the pleadings?
Sure. The scope of the pleadings also include punitive damages claims. And under 76872.
On battery and false imprisonment.
Correct. And we have to show and demonstrate the ratification or active participation or condoning of these actions by management. And he can speak to all of this because of violations of internal policies, the failure to train Catherine Beatty, which is pled, in her anger management issues, allowing her to continue over this child, leading inevitably to the battery and false imprisonments and all the other misdeeds that she committed against Mike Kowalski, as she's testified to here. So management and risk management are materially relevant to our case here. The issue of risk management not only is subject to our pleadings, but has been up to the second DCA, as the court's well aware. So the nexus between risk management and mismanagement of this hospital has all been part of this case for now 2 years.
Hold on a second, please.
Reference is being made to Ms. Beatty's prior arrest.
No.
No, it was not.
No, this
That's
is in
out.
the hospital.
And I think I struck that last night as well.
I
all the questions.
understand you did, Your Honor. I thought I saw it referenced in some of his testimony or affidavit.
Oh,
That's
that
why
could be.
I
That could be.
I missed, what are you arguing? Mr.
Your Honor, additionally, on the pleadings, outside of the punitive damages argument, count 8, which is the medical malpractice count, incorporated count 14, which is the negligent training, supervision, and ratification of the physicians.
No, training, not negligent training.
And in the lead up to trial, there was an agreement between Mr. Altenburn and Mr. Elliott, I believe, he'll confirm, to collapse count 14 into count 8 to avoid another jury instruction on this issue.
There was an offer And there was never an acceptance because they never gave me jury instructions that could fit there. There's no agreement on that.
Then in that case, count 14 is still an active count. So
for negligent training only under a common law theory backed up by 766.166 and a reference to a Bill of Rights, which is a piece of material only admissible to establish a common law standard of care. There is a statutory Bill of Rights provision in the Florida statutes. It has no private right of action. It has a different penalty.
Well, we consumed all this time. The bottom line is, I guess he's testifying, and there's going to be lots of objections, and I'm just have to do the best I can with the rulings on the fly. Are there any other motions that are going to be very substantive like this that I need to know about so I can be ready for them?
Don't believe so, yeah.
Thank you.
from the plaintiffs, there will be.
Well, let's get them
We will.
quickly because
We will.
I guess we didn't get any exhibits, so.
Do you want to handle one or two, or you just want to? I'll leave it up to your honor.
Are they needed for this witness?
Couple of them.
If they're needed for this witness, then let's do them.
What do you need?
Well, I say that.
Mr. Whitney, which one or ones are we talking about?
Just if we could.
I'm sorry?
If we just have a moment to decide which one Mr. Anderson would like for this witness.
We don't argue things that are either already in evidence or we don't need from this witness.
All right, we'd like to address Exhibit 2277, pages 245 and 246.
Let's put it up.
Your Honor, we recognize that there would need to be redactions. I would focus the court on paragraph number 3 in Ms. Salisbury's email regarding billing.
Judge, this is the DCF attorney writing an attorney for the hospital regarding DCF matters and things that she's concerned about.
I think it's the Kowalski's attorney.
Yes, I'm sorry, the Kowalski's attorney writing the hospital in the DCF hearing.
How are you intending on using this?
Notice, Judge.
Notice on what?
We brought to their attention, if I could, yeah, I got it. I have reviewed records indicating the child is being treated for, quote, complex regional pain syndrome. I guess it's the code, and it gives the code medical confirmed, would like verifications. Further, I would like an explanation of what medical confirmed means. The purpose of this is to demonstrate that it was brought to the attention of the hospital during the course of this on November 11th. And it starts out a printout of the child's diagnosis.
My recollection is the hospital agrees it was billing under the CRPS. I don't think that's an issue in the case.
No, it's not an issue in the case anymore, but the timing of it is when they were notified of it and whether they continued to do it.
Okay.
What does that have to do with anything?
Well, I think it would go to our fraud count regarding the billing as to whether there would be the required clear and convincing standard on it, that it was brought to their attention They knew what the problem was. They chose midway through her stay to continue to bill for serious.
I mean, it's to one of the lawyers here.
We were hoping to fix that was simply to delete names and just make it to
The
defendant.
unfair prejudice of this exhibit outweighs any probative value, even if I were to figure out a way to splice it to only get to that small paragraph.
I understand the court.
That's out.
What's the big holiday here? 2277. No, I'm sorry. 2123, pages 833 to 837. That's already in.
That's submitted.
That's already admitted. My apologies. But if we have time for one more, we would like to address 2277-453. Yes.
Put it up. What is this?
That's exactly the point, Judge. It's undated notes that somebody's going to have to interpret. Nobody's going to testify as to who wrote the notes, what they mean. If somebody picked up my notes from today, they would have to interpret them and try to figure out what the heck they meant.
We can withdraw on that.
It's from the risk management file at the hospital.
Did Mr. Anderson just say he will withdraw?
Well,
yeah, he did.
Yeah, then let's go to the next one.
There was one of these that had Ms. Crane's note on it, and that's what I thought this one was. Nursing notes pull out. Nursing notes pull out. Do we need it for this witness? Okay. Yeah, I don't think we need it for this witness.
Does anyone need to take a break before we start? We've been here for 40 minutes, or anyone want to take a break, or you want to get going?
I think we have time for a break if the court would like one, simply because we've got.
I'm fine. I'm just asking the lawyers if you want one.
Well, the defense would like a 5-minute.
Let's take a 5-minute break then. Buddy, hey, before we bring the jury in, what witnesses are we going to have tomorrow? Plaintiffs.
Depending on the length of this testimony, we may have to push our next witness in tomorrow, which would be Jessica Blackrick. We also have Deborah Salisbury and Brian Gillis. They testify tomorrow. We have a rather long deposition, relatively, of Dr. Eli Newberger and deposition excerpts of Dr. Sally Smith. And if we can get to it, the Kowalskis will begin their damages testimony.
If I may inquire, I can't see what Ms. Salisbury or the other attorney, I've forgotten his name, could possibly testify to in this action that's not going to invade what went on at DCF. So if we could get a proffer from the plaintiff so I know what to prepare for.
Especially with Ms. Salisbury. So what's Ms. Salisbury going to testify to?
I wish I had my notes in front of me. I know she's been instructed not to get into anything involving the DCF matter, but she was involved in sending warnings to the hospital about certain behaviors. And so, again, it goes to the notice to the hospital that Kathy Beatty was acting out as against Mike Kowalski. I wish I had my notes here.
And she can also speak to the factual scenario of the Morris transfer that we've heard a lot about.
Yes, that's right. I'm sorry.
Well, the first area of inquiry I would think would be entirely both duplicative and potentially privileged if she's going to come in and say, as the attorney for one of the Kowalskis, I was sending warnings.
Well, it's not your privilege to be concerned about.
Sorry, go ahead, Mr. Lee.
It's not only that, Judge. These matters were squarely in front of Judge Hayworth in the dependency action. She was dealing with Judge Hayworth in the dependency action. And the matters that are being alluded to were brought to Judge Hayworth's attention in that dependency action and dealt with at that time. So this is a matter, once again, of us going into matters that were before the dependency court that are not only duplicative of what we've heard already, but also were before Judge Hayworth and subject to his jurisdiction at the time.
Well, obviously, if it's talking about the dependency court, I'll shut it down, just like I've been on everything else.
We have big red lettered things. Don't ask this. Don't get into this on our desk.
But I mean, if there's a notice that's separate and apart from what was transpiring within the dependency court, perhaps that is relevant. Maybe it's cumulative, maybe not. I don't, until I hear it, I won't know.
And who is the other gentleman that they're having coming in for?
Brian Gillis. He would be similar.
Was he the attorney for DCF?
He was an attorney for DCF at the time.
And what is he going to be testifying to?
Again, Judge, off the top of my head, you remember Mr. Gillis?
One issue would be the issue that arose with Catherine Beatty's email that we tried to have admitted and the factual assertion that there was a delegation.
The email you sustained?
Yes, sustained it with the additional instruction that the defense could try to prove up a delegation.
I think it's also important to note that I do not believe Mr. Gillis was actually working on the Kowalski dependency case, and he is currently Deborah Salisbury's practice partner.
Was he the DCF attorney at the time?
I would defer to Mr. Whitney on that. My understanding was he may have worked for DCF, but he was not staffing the Kowalski case.
This is the point, Judge. Yeah, we have no information that suggests that he has any involvement in this case, except to the extent that he used to work for DCF back then, but had no knowledge or involvement in this case. So when he's been injected in the case before, it's been offering opinions about what DCF should have done or what should have been done in this situation, like a de facto expert of some sort, but yet he's never been listed as such, and he has no personal knowledge of events here that we're aware of.
Are we calling him for the dependency action? Because you know that's not happening.
I know that is not happening.
So what is he being called to say?
Without my notes, I can't tell you specifically, but I will reevaluate whether we can call him and take any risk with it. Honestly, Judge, I've been concentrating, trying to get ready for this witness and get things going and dealing with their motion.
Have we turned over the exhibits that we're going to use tomorrow?
Yes, Kelly Perry takes care of that. Can we check and ensure Kelly Perry is?
Yes, they were sent at 12:01.
Okay. Anything else, Mr. Hunter?
Well, two other matters. One is, I really would like to hear some explication of what we're doing with Mr. Gillis, because otherwise we're floundering around all night trying to figure out what this guy's going to say with no indication of what he in fact is going to be proffered for, and just wasting a lot of time. And then the second thing is, did I hear Jessica Stevens on the list for tomorrow?
Jessica Blackburn.
Jessica Blackburn. She is with the Guardian Ad Litem program, but we don't know what she's being proffered for, and if it's a Williams rule situation, we're going to have.
It's not Williams. It's not Williams rule.
Okay. So for those two witnesses, why don't we have a discussion after the jury leaves, before the lawyers leave, so we know this way somebody, if your law partner can scan your notes and send them to you, That
Yes.
way we can have a more intelligent discussion before everyone leaves here today, so we can be more targeted and focused tomorrow.
I understand. Oh, one other thing for the record, Judge. When I said withdraw 453, that was the last exhibit that we were discussing there. I think it was 277, 453. That was just as
words all over the place.
Say again?
It's the one with words all over the place.
Yes, we weren't withdrawing that completely forever. We were simply withdrawing it for the purposes of this witness.
Okay.
Judge, I apologize for this request, but I've looked at their redacted exhibit and I didn't take the best of notes. And can I ask the court to look at it to
Yes,
make
please.
sure that it's in conformance with the court's ruling? And I don't know about the other one. You only gave me the one exhibit.
The top two are fine. The bottom one, and just so the transcript's clear, I'm looking at 2277-630A and 631A. The bottom one looks like what I said this morning, but without being able to compare it to the one I actually ruled on. But it looks
628, 629.
what?
Would you like me to publish the other one?
I mean, if you could pull up the other one, but I think so I can see the underlying. But I think this is what I said.
Would you like to see 628, 629, or the other ones?
If I can see the original without the A, the 628 without the A.
Got it. Just a moment.
But Ms. Crows, this does look.
I wasn't suggesting it wasn't, Judge. I just wasn't clear and didn't want it going in.
Just a moment. No, unredacted.
Yeah, this conforms with what I wrote earlier today.
All right. Thank you, Judge.
Thank you. Anything else, or can we bring the jury in?
I'd like to proceed.
Let's bring in the jury.
Yes, sir.
Rise, jury stand jury.
Okay. Welcome, members of the jury. Please be seated. Did you have a good lunch?
Yes.
Okay, glad to hear that. I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And I want to confirm while you're away, you reviewed a whole bunch of media about this case. No, great. Has anyone approached you about this case since you were last with us?
No.
Mr. Anderson, your next witness, please.
May it please the court, I'd like to call Dr. Joseph Corcoran.
Stand here.
Raise the cloak and raise your hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Hi. Can you please state your name for the record?
Yes, sir. I'm Joseph Corcoran.
MD?
DO.
DO. And where do you live?
I live in Tampa, Florida.
And have I asked you here as an expert in hospital administration to advise the jury on your review of the policies and procedures at Johns Hopkins All Children's Hospital during the relevant period?
Yes, you have.
I'd like you to give the jury the background, a little bit of your background training and experience for offering opinions here today, particularly your well, why don't I let you start?
Good afternoon. So I'm Joe Corcoran. I am an OBGYN by background. After finishing my residency in Philadelphia, I practiced in Sarasota for about 12 plus years, from 1991 to 2003. I'm board certified by the American College of OBGYN. I spent my first 3+ years working for a large practice. In March of 1995, I started my own practice with the idea of keeping it small and boutique-y. That didn't last very long, and the practice actually grew fairly quickly. By the end of my term with the practice, I believe that we had 3 physicians, 3 nurse midwives, and 4 nurse practitioners serving a variety of offices, one of which was here in Venice. The main one was in Sarasota near Doctors Hospital. In 2003, shortly after I became a dad, I had what should have been routine back surgery. There were complications after the back surgery that ended my clinical career. I was unable to continue to stand, bend, lift, twist. Obstetrics is a fairly physically demanding specialty, even though the babies are fairly small. So it took about 2 years for me to get better. And I did that recuperation at home in Sarasota. In 2006 or 7, I started a business education master's program at University of Florida in the Warrington College of Business. I graduated with a Master's of Science in Entrepreneurship and Innovation. Shortly after graduation, I was recruited to a healthcare think tank in Washington, D.C., known as the Advisory Board. It's been around since the early 70s and is now part of Optum Healthcare. I joined in November of 2008. My first day on the job was the day before we elected Barack Obama as president. So it was really kind of neat to have a front row seat to the development of the Affordable Care Act. I had nothing to do with the legislation. We actually helped hospitals and large medical groups know how to change in this new paradigm. I was with the advisory board through the beginning of 2013. At the end of 2012, just prior to the election between Barack Obama and Mitt Romney, I was asked to deliver an address at the Longboat Key Club in Sarasota, talking about what would a second term of Obama versus a first term of Romney look like for healthcare. There were some executives from HCA in the audience. A conversation started that evening that ultimately led to them offering me the opportunity to work with HCA Healthcare. HCA Healthcare is a for-profit hospital company. It currently has about 180 hospitals, I believe in 20 or 22 states. So I was offered the opportunity to become the chief medical officer of Brandon Regional Hospital in suburban Tampa. It's about a 350 to 400 bed hospital at the time. I was in that role from 2013 until 2018.
Did Brandon, I'm sorry to interrupt, did
Yes, sir.
Brandon have pediatrics as well?
Brandon always had a pediatric capability, but during my tenure, we actually developed what we referred to as a hospital within the hospital, so that we had a dedicated pediatric emergency department that had a separate entrance from the adult emergency department, and we had a dedicated floor for pediatric patients, including a pediatric ICU, and of course, being a heavy OB hospital, we always had a neonatal unit as well for newborns.
Please continue from there.
Thank you. So in the fourth quarter of 2018, based on some progress that I had a hand in at Brandon Regional, I was given the opportunity to assume a larger role within the company. And for better or for worse, that included a move out west. I became the division chief medical officer for the Far West Division, which has responsibility for about 35 cares of site total, but 5 acute care hospitals in the state of California, 3 acute care hospitals in Las Vegas, Nevada, including Sunrise Hospital, which is about 800 beds today. If I'm not mistaken, the Sunrise Children's Hospital, which again has a separate entrance and a separate emergency department, accounts for 206 of those beds. I was in that role for about 3 years, including when the nation learned about COVID. One of our hospitals in the Silicon Valley actually had patient number 2 in the whole country. So we were kind of winging it. We were figuring it out. And a lot of what we did in managing the early cases in California and some in Nevada actually set the foundation for how the rest of the company managed COVID across as it spread from the West Coast. I was in that role for about 3 years. I left the role because, quite simply, it came down to a job that I loved and a family that I adored. My wife and my 2 kids were never able to move out west, so I was commuting about 2,000 miles, 5 hours by air. And my kids are my world, so that became unsustainable. So at the end of 2021, I moved back east. And in the early part of 2022, I accepted an opportunity to step away from full-time service to HCA Healthcare and take on the opportunity to serve interim roles. So they would drop me in basically as a consultant, and I would work, 3 months at a time, engaged at a specific hospital, trying to address more specific problems.
So did Sunrise Hospital, can you elaborate a little more on what your job duties were there at HCA in the Western Division? And particularly, Terry would like to know about Sunrise Hospital and the other pediatric units that you were involved in.
Yeah, so Sunrise Hospital is a very large safety net hospital. As I said, it's over 800 beds today. The night of the 1 October shooting, you may remember where there was a sniper at the Mandalay Bay Hotel. The night of that shooting, 100 patients were taken to the county hospital, the old Clark County General, which ultimately became University Medical Center. They accepted 100 trauma patients and then shut off and went on divert. Our hospital emergency room took over 350 patients in that night. We always felt that we had to be there for the community. So it was very much a safety net hospital. It was, really kind of, it was off the strip. It was not the glamorous part of Las Vegas. The Children's Hospital, and Mr. Anderson, I want to make it clear, as the division chief medical officer, I had a facility chief medical officer at Sunrise who really was more responsible for the day-to-day operations.
Did he report to you or she?
He did. Yes, sir.
Reported to you?
Yes, sir.
All right. So you were over the administrator there in terms of problem solving and operational decisions?
So my focus was always on clinical quality and patient safety. That really is job one for a chief medical officer. So I want to make clear, I was not over the entire leadership. There was a CEO who really ran responsibility for the hospital. My job was to support, lead, direct the chief medical officer at the facility, who also had the responsibility for clinical care and quality. Safety, I'm sorry.
And you said you're married. How long have you lived in Sarasota, setting aside your trip out west?
So I moved to Sarasota in the summer of 1991 after finishing my residency. I was a little bit of a slow learner. I didn't get to meet my wife until 1998. So I was single for a long time. And I lived on Siesta Key for most of that time. I met Patty in 1998. We got engaged in 1999. We got married in 2000. So we've been married a little bit over 23 years now.
And is she involved in business as well?
Yes, sir, she is. When I met her, she was helping her mom and dad run El Greco Cafe, which was a Greek restaurant down on Main Street in Orange in downtown Sarasota. And it's funny, I actually remember sitting at the intersection waiting for the light to change and saw the logo that said, where it was Greek cuisine, where Athens meets Sarasota. And I thought I wouldn't even know what to order if I ever walked in. Little did I know that I would end up marrying Patty just a couple years later. She now works with her sister and our nephew, and they have started a new chain of restaurants called The Breakfast Company. There's one in the Landings. There's one on State Road 70. And soft grand opening was yesterday for the new site across from UTC Mall.
So how did you, lack of a better term, get this gig? How did I find you to advise the jury on these issues?
So one of my longtime friends is Steve Heese. Steve is someone that I met during the Reagan administration when I was doing my residency in Philadelphia. Steve is a very smart businessman. He ultimately went on to be one of the owners of Chris Craft Boats.
This is irrelevant as invoking third parties who were not parties to this have nothing to do with it.
Sustain. Let's.
I'll speed it up, Your Honor.
You knew Steve Heese and...
I knew Steve Heese. We had dinner. Our wives are friends. So the four of us were having dinner. Steve actually knew Greg as his chief counsel, I believe, for Chris Craft Boats.
No objection, Your Honor.
Sustained.
That's all I had on that, actually.
We're tired of the witness, Your Honor.
I'm not completed.
Why don't you let him finish? Thank you.
Yeah, exactly.
Finish the credentials. portion.
Okay. All right. So in terms of operating hospitals and in advising the jury on your opinions here today, tell the jury about your practical experience in evaluating the operations of hospitals and noting where there are issues that must be resolved.
So it started my involvement in assessing and helping hospitals run smarter actually began when I was in practice. I was on the medical executive committee of Doctors Hospital in Sarasota for 4 years. I was elected as the chief of staff, but my surgical complications did not allow me to fulfill that role. After graduation from business school, as I said, I was recruited to the advisory board, which was a think tank and a consultancy. So my roles involved going to health systems, hospitals, and large medical groups, giving them business insights about how to work in this new Affordable Care Act paradigm primarily. And then for HCA, as I said, I was a chief medical officer at Brandon, which was about a 375-bed hospital, which has subsequently grown, and then had responsibility for about 3,500 beds all total between California and Nevada in my role as division chief.
And can you explain how HR, if you will, played a role, whether you were either directly involved or over and making decisions in terms of the HR departments in these different hospitals?
So I didn't have any direct responsibility for the HR department, but I did have leadership responsibility or executive accountability for the medical staff office, and that was a responsibility that I shared with my CEO. I had direct responsibility for the quality department, and I had a VP, a vice president of quality who headed up that department and had maybe half a dozen to a dozen members on her team. I also oversaw a couple of other organizations, including computer physician order entry.
Were you involved in some of your roles in the development of hospital policy on various topics?
Yes, sir. So I didn't write the policy, but we met with the folks who did. That typically was somebody with a legal degree, so that we made sure that we wrote it the right way. But yes, I was involved in those conversations as they applied to clinical quality and patient safety primarily.
And some of the different policies and procedures that we will discuss here today, have you been directly involved or overseen the direct involvement in the development and management of those policies?
Well, not the policies that we'll look at today, but policies like that as they applied to
obviously not
our
these,
hospitals.
But,
yes, sir.
But in other hospitals.
Yes, sir.
And then in terms of your as Chief Medical Officer in Brandon Regional Hospital, then, can you explain your role in terms of overseeing or developing hospital policy and procedures of the type that we'll be discussing here today?
Yes, sir. So, for instance, one of the things that we did, aside from just writing policy, was actually working on performance improvement. So, for instance, shortly after I started at the hospital in the early part of 2013, we participated in an effort to improve how we were doing with sepsis, which is an overwhelming bacterial infection. When I joined the hospital, if you were diagnosed with septic shock, there was a 44% chance that you would die rather than be discharged home. That was unacceptable from a clinical perspective. Average nationally is about 30%. Before the end of the year, we actually worked as a team, and I had a part in leading that team. We worked as a team to put in new procedures based on what evidence and data showed us was the right path. We created guardrails for our clinical teams to stay between.
What's a guardrail?
That's my term for it. We said, look, the data and evidence says that this is acceptable and this is acceptable, and there's a range, right? So I think about it as guardrails, and we leave which lane to be in. We leave that up to the physician based on their knowledge, their skill, their education, their judgment. But we know that if you stay between the guardrails, the data and the evidence points us to the patient is more likely to get the favorable outcome that they want and we want for them. So we were able to lower our mortality rate from 44% to 24%. And we maintained that performance for several years in the mid to low 20s.
And can you explain your involvement with the standards that you'll be speaking about today? They're called CMC or CMA?
CMS?
CMS standards.
Yeah. So, lawyers frequently talk about standards of care, and that's a legal definition about what is expected a physician to do when treating whatever.
Sure.
Continue, Mr. Anderson.
And insofar as the CMA standards, based on the court's ruling, I want to ensure that we just stay involved with your knowledge of the development of them, any participation you had.
Sure, and it's CMS,
CMS.
Center for Medicare and Medicaid Services, which is the federal organization that oversees Medicare and Medicaid spending. So I had nothing to do with developing the CMS standards, but these really are there's a book referred to as, titled CMS Conditions of Participation. And these are the standards that every hospital is held to if they want to participate.
Yeah, I know.
Sustained.
Yeah, we can't go into the operation of them, just your background in terms of actually learning about them, using them, developing them.
Understood. Thank you. So the CMS standards were what I, as a practicing physician and a physician medical staff leader, was held accountable to. The standards were also what I was held accountable to as a chief medical officer, to make sure that my hospital was meeting those standards.
Objection is sustained.
I'm sorry.
So, and for the purposes of this testimony, let's stay away from the CMS standards and simply go with your background, training, and experience on this.
Yes, sir.
So, what did you review in connection with offering opinions here today?
I was provided with a variety of documents, which I've listed out in this.
If you could give the jury just an overview of everything that you'd received towards offering opinions here.
Will do. It's quite lengthy, but it's multiple depositions from some of the treating physicians, from Catherine Beatty, some documents from Johns Hopkins variety of organizations, including All Children's Hospital. Some policies and procedures from from All Children's Hospital, the medical staff rules and regulations dated February 2016, depositions of Dr. Napolitano and Perno, Patty Condon, Jackie Crane, organizational structure, org charts for Johns Hopkins All Children's Hospital, reports from various experts.
Okay. And what was your assignment here?
So you asked me to be a part of this this litigation, this case, to really help the judge and jury understand how hospitals work. They're very complex. They're very complicated. The hospitals that I worked in, Johns Hopkins actually has another layer on top of it because it is an academic medical center, which has its own kind of fiefdom, right? So I was really brought on.
Object to relevance. Johns Hopkins is not part of the case.
Overruled. And if you can speak to any experiences you had where you were working with or developing things with Johns Hopkins, any one of them.
Yeah, so I'll be more precise about Johns Hopkins All Children's Hospital. I apologize. So I'm sorry, the question was, sir?
Well, That's a good point. I added on to it about any experiences you had actually working with Johns Hopkins in developing any policies, procedures, or other programs.
So I never worked directly with Johns Hopkins in Baltimore. When I was at Brandon Regional Hospital as the chief medical officer, as I said, we opened a pediatric hospital within the hospital. We actually worked with Jackie Crane, Dr. Napolitano, and other leaders from All Children's to help us build that hospital within the hospital.
For the pediatric aspect of it?
Yeah, yes, sir. It was a pediatric hospital within the hospital.
Okay. Now, so that the jury understands here, in terms of the hierarchies in hospitals, and can we bring up I guess it's now 2802 organizational chart, published, Judge, if we may.
Is it in evidence?
Yeah, it's the 2015 version we talked about.
I'm sorry, Judge, I want to rule out the witness when he gets done.
Okay, are you finished with your credential background?
Yes.
Then Mr. Hunter can body your.
Good afternoon.
Good afternoon, sir.
Just a few questions at this point. As I understand it, your first billet, if you will, as a hospital executive was at Brandon Regional Hospital?
Yes, sir. My first hospital-based leadership position. Yes, sir.
And before that, and to the present day, you had not practiced in a children's hospital outside of medical school, correct?
As an obstetrician gynecologist, yes, I have not practiced medicine at a children's hospital, and I apologize for not being more clear before.
Not a problem. And you haven't worked in a children's hospital since medical school?
That's not entirely true because, again, Brandon Regional had the children's hospital within the bigger hospital, and Sunrise Hospital has Sunrise Children's Hospital.
Okay, well, let's compare and contrast for a moment.
Okay.
Brandon Regional Hospital is a general hospital, correct?
That is correct.
Is it licensed as such by the state of Florida?
Sir, I'm not aware of the license.
You don't have any idea what the licensure classifications are?
That's outside my wheelhouse as a
Would you have any reason to doubt that it is licensed as a Class 1 general community hospital?
That's outside of my wheelhouse. I wouldn't even be able to comment on it.
You don't have any idea?
No idea.
Okay. We can agree that it takes adult patients.
It does.
That's primarily what it does, correct?
It does.
And it does adult surgery.
It does.
And the hospital within a hospital is just one floor of a general hospital, correct?
When I was there, it was limited to one floor. Yes, sir.
And that wasn't there when you started. It was something y'all developed.
That's correct.
Okay. It has nearly 400 beds.
Correct.
It's in a community as a community hospital, correct?
Yes, sir.
Doesn't have a reputation for referrals far outside as a tertiary care institution.
Actually, it does a lot of intake for some of the specialty work that it does, particularly in neurosurgery and other services that aren't maintained at most community hospitals.
And they're adult services.
Yes, sir. But we also took in transfers from newborns.
Okay. So if you had problems with a newborn, you transferred it, correct?
Well, we kept most of them at the hospital.
But if you had a complicated newborn, you transferred it to a children's hospital, correct?
For the most part, yes, sir.
Okay. Now, do you have any idea what the number of beds that All Children's has?
I believe it's in the neighborhood of 240, 250.
What is their licensure, do you know?
I have no idea, sir.
Do you know what the acuity level of the beds at All Children's are?
I do not.
Do you know how many NICU beds they have?
I do not.
Do you have any idea how many PICU beds they've got?
I do not.
To talk about your hospital in Las Vegas, you never worked in that hospital, did you?
I was in the hospital on a weekly basis, but I never had an office in that hospital.
you didn't have day-to-day responsibilities for being the CMO of that hospital, correct?
That is correct. I was that CMO's boss.
Okay. And you were over the top of him and didn't have command of the executive team, did you?
Not command, no, sir.
Okay. So you were not directly responsible for operations in that hospital. You were supervising what your employee did in that hospital, correct?
I was accountable to the work that was done there,
Okay.
but not responsible for the day-to-day operations.
Okay, that's my point. Okay, so how many beds was that hospital?
The hospital writ large is, I believe, just over 800 beds, and I believe just over 200, I believe it's 206 of those are part of Sunrise Children's Hospital.
Is it separate?
The hospital is a multi-block complex. Sunrise Children's has an entrance on the south side of the complex. The adult hospital has its entrance on the northwest corner. The emergency room is, both the adult and children's emergency rooms are on the east side. So I don't know how to answer that. They are, when you're leaving one hospital and entering the other, but there are contiguous hallways.
Are they separately licensed?
To my knowledge, they are.
And how are the licenses classified? Do you know?
Again, that's above my pay grade.
Okay. What is the acuity level of the beds at the Children's Hospital?
So the Children's Hospital actually has every conceivable level of service, not level of service, every conceivable clinical service, including open heart. They have a very active open heart program. They have neurosurgical, pediatric open heart, pediatric neurosurgical. Sunrise Children's is the tertiary care hospital for the state of Nevada.
Okay. And your responsibility was overseeing the CMO of that hospital?
My responsibility, my accountability to my bosses in Nashville was to make sure that that hospital was running. I relied on my chief medical officer as my right hand for making sure that that happened. But at the end of the day, if something went afoul, I had to answer to it.
And when were you working with those folks?
Began in the fourth quarter of 2018, and I finished in the fourth quarter of 2021 for 3 years.
So those 3 years, but during the time that this incident took place, you were at Brandon Hospital, correct?
That's correct.
And at the time this incident took place, you had not worked in a pediatric hospital in 30 years, correct?
Again, that goes back to my clinical career.
Yes, sir.
Yes, sir.
But
might not be 30, but more than 15.
Going back to medical school?
And residency training, so up to 1991. It's pretty close. We're getting old, aren't we?
All right. That's all I have right now. Thank you.
Thank you.
Okay, now, if we could bring up, I think what I was doing here is having, okay, this isn't confusing at all, is it? All right. Let me represent to you, and for the record, this is Johns Hopkins All Children's Hospital. Well, actually, let's identify by exhibit. Where is it? I gotta get set up here again, Judge. All right, so this is exhibit Johns Hopkins, actually 2802. The Johns Hopkins organizational chart as of 2015, the year before what we're talking about here. Now,
I'm sorry, the date on mine says February of 2016.
Are
you looking at the same?
I think it was 2015 issued and 2016 on it.
No, we said 2016.
It's revised 2022, 2616.
All right, so it's 2016.
Okay.
Okay, can you take the jury?
Your Honor, may we approach? Sorry. We have an issue with this exhibit.
We're just trying to keep all our paper in a row here, so sorry about that. But I think we've figured it all out.
I'll keep asking questions. All right, so before we get to the organizational chart, can you tell the jury a little bit of the history of how All Children's Hospital became Johns Hopkins All Children's Hospital, to the best of your knowledge?
Foundation, Your Honor.
Sustained.
Are you aware of the circumstances surrounding the acquisition, of the date and the general terms of how Johns Hopkins how All Children's Hospital became Johns Hopkins All Children's Hospital?
Foundation, Judge, if we need to approach.
You may continue, Mr. Anderson.
Show you what's in the evidence as 2200. And ask you if this was something you relied on in reviewing the background of Johns Hopkins Children's Hospital.
We have the exhibit number
2300. And
Yes, Mr. Anderson, it is.
can you tell the jury approximately when All Children's Hospital became Johns Hopkins All Children's Hospital?
On April 1st, 2011.
And is Johns Hopkins All Children's Hospital part of the Johns Hopkins Hospital system? If you know.
I believe that Ms. Crane described it as the sole corporate member, JHHS.
Right.
And they did appear on the 2012 org chart. I've not seen the 2016 version.
So then let's bring up the 2016 org chart, if we have it now. Yes. All right. Oh, this is just so much less complicated. Now, can you, the first thing we'd like to know is your position at when you were working for Hospital Corporation of America. Where would you fit in this? Was there a similar position?
Well, I don't see a specific box that identifies chief medical officer on the on this All Children's Hospital Chart 1.
Right. Okay. Are there any equivalent positions there? Just to orient the jury.
Right, I'm looking. At the time, I believe they had a vice president of medical affairs, Dr. Brigitte Mueller, in 2016. I'm looking for her box on this org chart.
Let's go to the next page, please. And what I'm looking for here, and you can stop us when we. What I'm trying to look at here, and there's Dr. Muir. So this position right there.
I see it.
Okay. So let's then, if we can scroll through the next page. All right. What I'm trying to establish here is the chain of command from the president down to risk management. Okay. Now, if you can identify risk management, which I used to be able to on the old chart.
Right. So risk management is on the upper right corner. Right. Thank you for the red box. Risk management is one of 5 organizations that report directly up to senior counsel, Jackie Crane. Jackie Crane then has direct reporting responsibilities signified by a solid line.
Yeah.
One goes directly to President Chief Executive Officer Jonathan Ellen, MD. One goes to the right to JHHS, which is the Baltimore-based organization. And then one goes further to the right to the internal auditor.
All right. So in terms of the level, I see that the risk management department is separated off to report directly up to the senior general counsel.
Objectively, Your Honor. Overall, you can answer.
Yes, that is correct. Risk management was responsible for reporting up to the senior counsel, Jackie Crane. I just want to point out, our expectation as leaders is that you not only expected your reports to direct.
Your Honor, it's not responsive to a question.
Sustained.
All right.
Thank you.
What, if anything, is different about this that you're about to explain?
I was just going to explain that there's a push of information up to your boss. Rule of thumb, never let your boss be surprised. But there's also a responsibility to pull information up because you are accountable as a leader to the organizations that you lead. You can delegate out tasks. You can delegate out.
Your Honor, some response to a question be editorial comment has no foundation.
Overrule the foundation, but let's have a question next time.
Well, why is the pull part of this so important?
So as a leader, you are responsible for what your teams are doing. So they should be reporting up to you, but it's your job, if needed, to pull information from them so that you have a clear understanding of how they are performing on tasks that you have delegated down to them.
So for the general counsel, senior counsel right here, and the senior counsel reports to the president?
That's correct.
The general counsel,
senior counsel,
for your background training experience, would that he or she have a duty to pull information then on a timely basis from risk management?
Objection. A lack of foundation in this organization, you speculate.
Let's just go with non-speaking objections, please.
Foundation, speculation.
Overrule.
You can respond.
Yes, sir. In an organization such as this, you would expect that there would be a push and pull accountability.
And would that be on a reasonably frequent basis? Or
Generally, I would meet with my direct reports on at least a weekly basis, if not more frequently.
All right. So if you could then tell us whether, as to this chart, then the risk management was directly reporting and the senior counsel directly pulling information up to the most senior levels of executives in this operation.
Objection, Your Honor. Relevance 403, lack of foundation. Overrule.
You can answer.
Yes. So the senior counsel should have been getting information from risk management on a recurring basis and sharing the most relevant information up to the president, chief executive officer, and JHHS, and as needed to internal audit.
Now, are you generally familiar with the facts of this case, the Kowalskis versus Johns Hopkins All Children's Hospital?
I am.
And are you familiar with the facts leading to the time spent by Maya Kowalski at Johns Hopkins All Children's Hospital from October of 2016 through January of 2017?
I am.
And what was significant to you in your review of the facts there that would make this case one that the senior counsel would or should have rather had continuous knowledge of?
So this case was.
Objection, Your Honor. Relevance foundation outside, please.
I need to hear that question again, please. Mr. Court reporter.
Okay, John, what was the significance to you and your view of the fact that there would make this case one that the most senior counsel would or should have rather had continuous knowledge of?
What was those last few words? I'm sorry.
What is this beginning of his answer? He just said, so this case was, no objection.
Well, let me, Mr. Anderson, why don't you ask the question again, because I didn't quite hear what the court reporter said.
It was what we call an inartful question. What I'm asking here is, based on your knowledge of the facts, can you explain to the jury why this case, situation, whatever you want to call it, about the Maya Kowalski situation, was one that should have, if it didn't, reach the level of senior management?
Objection, Your Honor.
Overruled. You can answer that one.
Thank you. So in multiple depositions, including those that were aired this morning, it was clear that risk management was involved in helping to influence or make decisions regarding or supporting Maya Kowalski's care. The references in the depositions suggest that that was a fairly frequent conversation. On page 166 of Catherine Beatty's deposition, she describes conversations that she had with risk management that describes, quote, "this case was different."
Object to this period of testimony.
You can simply just, without reading it in, just reference
Sure.
references.
I'm sorry.
That's all right. Have you ever testified before?
No,
As
sir.
an expert?
No, sir.
All right, so.
Your Honor, court, please, this witness seems to have been reading from something just a moment ago.
He's got the deposition.
I'd like to know what else he's got.
What do you have there? Show it to Mr. Anderson, who can show it to Mr. Hunt.
Sure.
It's his file.
Mr. Anderson, why don't you go get it and show Mr. Hunt?
Your Honor, court, please, thick notebook that appears to have select.
Why don't you come pop up here?
So.
Hold on a second. This is what we're gonna do. We're gonna put the notebook back there, we'll leave it closed.
Okay.
If you need to refresh your recollection, just let us know.
Okay.
We can open it up and then the lawyers will come up and we'll get whatever you're looking at.
Understood.
Okay, thank
Yes,
you.
sir.
You may approach.
You may.
Thank you. Yes, sir.
Now, where were we insofar as the reference or sources for your opinion?
I'm sorry. Can you reorient me?
Yeah, can we read back the last question?
Let's go. because you can simply just without reading and just references.
I think the one before that.
What I'm asking here is based on your knowledge of the facts, can you explain to the jury why this case, this situation, whatever you want to call it, about the Maya Kowalski situation was one that should have, if it didn't reach the level of senior management, then there was an objection.
Thank you. Thank you for that. So as I said, risk management seemed to have pretty recurrent involvement in the case. That's the risk management department. The case was described by Kathy Beatty in a conversation that she cited in her testimony as being different, and discussing that with risk management and explaining multiple reasons why she felt it was different.
And so, armed with that information, what should have happened if it actually didn't?
So if this was a case that was constantly pinging in risk management, it seems reasonable that that would be shared with the executive who's in charge of risk management. That would be Senior Counsel Crane.
And so I believe we have an email here from.
Is that one been, actually, the one in
We'd like to publish at this time 2277, 628, and 629 alpha, previously admitted evidence.
You may.
Right. Now, do you note here who this is from?
It's sent from Patricia Condon.
Are you aware of her position?
It indicates that she's a risk management analyst at Johns Hopkins All Children's Hospital.
And do you recognize any of the recipients?
It is sent to Jackie Crane, who was senior counsel. It was sent to Louise Barnes-Kurth, who I believe was the head of risk management at that time, and Cindy Driscoll, which is a name that I do not recognize.
Now, if you would review this as to the topic here, you see where they are continuing the allegations of, quote, self-inflicted
I do.
wounds, scratches. And then, and if we can keep scrolling down, and how they were asked about lesions from Ms. Kowalski, either directly or through her counsel.
Leading Your Honor.
What I see is a quote from Ms. Condon. I did advise Dr. Majors to get pictures of the scratches. I need her to inquiry with Maya how she got them.
And
just reading the exhibit once again speaks for itself.
That's not how witnesses read exhibits.
does it appear to you that Dr. Majors, then, from this, was advising, or Patty Condon, rather, was advising Jackie Crane, among others, about the incident where Maya, what the jury has heard about, where Maya was stripped down, held down, and photographs taken?
Calls for conclusion. Objection calls for conclusion. Relevance. 403.
We're willing to go relevance. We're willing to get our objections. You can listen.
This does reference a direction, advice to get pictures of the scratches.
And assume for the purposes of this question that the photographs taken of Maya Kowalski were never analyzed as part of the medical records, and an after set were never taken, and that this just appeared to be an unpleasant, highly unpleasant situation for Maya Kowalski without any authorization from parents or anyone else? Is this the type of incident that should be reported up to the highest levels?
Objection, Your Honor. It seems facts not in evidence. Can we approach on this entire matter just a moment?
Sure, you can approach. You can re-ask the question.
Thank you. Do you have an opinion based upon your background, training, and experience into a reasonable medical, do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether the senior level executives at Johns Hopkins All Children's Hospital were made aware of the situation involving obtaining pictures of Maya Kowalski?
Objection, foundation, and proper hypothetical.
Overruled. You can answer.
From this email, it's apparent that Jackie Crane received this email and the information was there for her to receive.
And based upon your background and training and your knowledge, what would be the appropriate thing to do if a senior level person, management level person, received reports that could be construed as a battery upon a child? What should they do?
In my experience as a chief medical officer, if I saw information like this from one of my direct reports, I would investigate. I would get involved. I would make sure that I understood what was going on.
Would you get personally involved, is what you're saying?
Absolutely.
Form and objective relevance.
So now, from your review of the facts of this case, can you tell the jury, and strike it, and have you had the opportunity to review various emails and other documents involving the exchange of information between Ms. Condon, Ms. Crane, and others between the Risk Management Committee and the senior level to determine whether there was an appropriate response back down from senior management to investigate this further?
I have seen emails where information was shared with Ms. Crane. I've not seen any emails that there was a response directing other actions to be taken.
And assuming that these photographs were taken several days later, do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether this failure to investigate caused or contributed to the injury done to Maya Kowalski from the photo session?
Objection, speculation, foundation.
Yes, sir, I do have an opinion.
And what is that opinion?
I believe that it did contribute to the injury. And I think that I was here on Monday and I heard that loud and clear from Maya Kowalski herself.
And in this instance, strike. I'd like to bring up Exhibit 1082, and for the record, that's the Johns Hopkins patient family rights there. And if we could go to the next page that sets forth the actual, and then if we could go down or look at the first two under expect privacy and always receive polite and now, based on your knowledge of what happened to Maya Kowalski just in this incident, do you have an opinion based upon your background, training, and experience as to whether Johns Hopkins All Children's Hospital violated its own internal statement of rights to patients?
Objection to relevance outside the pleadings.
Overruled.
Yes, I do have an opinion.
And what is that opinion?
I do believe that there were episodes that have been reported in testimony that were outside of these directives as rights that patients should have and expect.
Same question as before. Based on your background, training, and experience, if a senior member of management learns that patients' stated rights are being violated on a consistent basis, what should they do?
Objection, Your Honor. Relevance foundation outside the pleadings.
Overruled.
Again, as a leader, if I saw this kind of information coming up from one of my direct reports, yes, I would get personally involved and I would find a way to get us back on track.
And would that involve, what if any training would that involve as to the participants?
I would certainly make sure that they understood what the patient rights were that we were advertising as affording every single patient in the hospital. I would make sure that they understood what was in bounds and what was out of bounds.
And what if anything would you do to ensure that if a particular employee, in this case, let's say Kathy Beatty, rejected that training, what is your opinion based upon your background, training, and experience into a reasonable medical management probability should be the action taken with an employee in this situation who either fails or refuses to accept this training?
Objection, relevance foundation outside the pleadings, no foundation.
I don't understand the question. So I'm going to sustain it on my own. I don't understand what you just asked.
All right. Maybe I'll ask another. All right. So what is appropriate in this circumstance for the retraining of Kathy Beatty if there was a circumstance such as you have learned, repeated behavior violating the patient's internal rights? What type of training should be undertaken in addition to just educating them on this?
Objection. I don't understand that one. Same objection as before.
I sustain.
As to the training?
I don't understand your question, Mr. James. I'm sorry.
I'll move on, Jeff. All right. I would like to direct you over to the farthest column right before the black column right there, and the top has got an arrow next to it, and it involves the ability to talk to another physician outside of this. I want you to assume, for the purposes of this question, that one or more of Maya's treating physicians, in particular Dr. Ashras Hanna, attempted to visit Maya in order to gain an understanding of her physical condition, how she was doing, and that he was rejected not from trying to go and treat, but simply as a visitor who was a doctor. Do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether Johns Hopkins All Children's Hospital violated this right that Maya Kowalski had.
Objection. Relevance assumes facts, not an evidence, improper hypothetical.
Sustained.
There's been evidence of documented.
Sustained.
All right, now, has it come to your attention through your investigation that the Kowalskis were attempting to exit Johns Hopkins All Children's Hospital during the first 7 days of Maya post-admission?
Yes.
Has it come to your attention that over that period of time there was no court order that authorized keeping her there?
Yes.
I'd like to show and publish now Trial Exhibit 2237-005. And this is from the Johns Hopkins discharge of patient against medical advice. First, what is AMA?
Against medical advice.
Does it have the power of law?
No.
All right, so if we look at this chart down here, and we continue down, from your review of it and further down, is this describing what the Johns Hopkins personnel should be doing in the event that a parent disagrees with their proposed treatment and wants to just get their child out of there?
Objection, Your Honor. Relevance, foundation, lack of foundation, lack of credit.
This is the foundation.
No, approach, please.
Overrule the objections, witness can answer.
If we go to the bottom of Exhibit 2237-005, now leaving out the comment on the lower right, under...
I'm looking for the document. It's not up.
Okay. Let's put up 2237-005.
I've got it. Thanks.
Confusely. And if you look at this flow chart here, down below, in all cases, does it appear to you, and based on your knowledge of the power or lack thereof of AMA, that Johns Hopkins breached its own internal rules regarding the ability of the Kowalskis to leave simply on the basis of AMA?
Objection, Your Honor. It's leading improper predicate relevance to the foundation?
We just discussed that.
You can answer.
Thank you. So I wasn't a party to the conversations, but there is nothing in this policy or this flow chart that should keep Maya's parents from walking out the door. It may be against medical advice, but there's nothing here.
And to the extent that they prevented, in some form or fashion, either through security or through representation of some kind, the Kowalskis from leaving with Maya, and I'm talking about this period, the first week, do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether they violated this internal rule regarding AMA?
Objection, Your Honor. Relevance Foundation assumes facts not in evidence and fails to take into account Chapter 39. We object on the basis of the latter.
Limited to the first week, so I'm going to overrule the objection. He limited the question to the first week.
Understood, Your Honor. The 24-hour rule as well.
You can continue, Mr. Anderson.
Thank you.
Yes, I do have an opinion.
And what is that opinion?
My opinion is that they did not follow their own internal procedure.
And confining it then to just this week, we're talking about before there was any court intervention, do you have an opinion based upon your background, training, and experience and your review of the depositions of the Kowalskis and the facts of this case as to whether that action in violating the rules caused or contributed to harm to Maya Kowalski?
Same objection, Your Honor.
Overruled. You can answer.
Yes, I do have an opinion, and I do believe that it contributed to the injury.
I'd like to ask you, and I want to focus now, go back to 1082, if we could. I mean, I published, Judge, the same patient's rights.
You may.
All right. Now, if we look on the center column, the third from the bottom, where it discusses cultural values and spiritual beliefs, let me ask you to assume for the purposes of this question that Maya Kowalski was prevented on one or more occasions from practicing her religion, either by not being able to pray with or see her own parish priest, or by having certain materials taken from her or not provided to her, I should say, or by having this religion criticized. Do you have an opinion based upon your background, training, experience as to whether Johns Hopkins All Children's Hospital violated their internal statement of rights that they be allowed to practice their cultural values and spiritual beliefs?
Objection, Your Honor. Relevance, lack of foundation, the failure to take into account the interplay of DCF in Chapter 39 and outside the plea.
Overruled. You can answer.
You may answer.
Yes, I do have an opinion, and I do believe that they did not respect the patient rights that you've highlighted here.
Did you see anywhere, and strike that, did you have the opportunity to go through, if not all, the majority of the medical file during the time that Maya Kowalski was in Johns Hopkins from October of 2016 through January of 2017?
Did I have the opportunity?
Yes. Did you review it?
I did not review much of the medical record because I'm being asked not as a medical expert, but as an expert in how hospitals are meant to run.
Then I'm not going to ask the next question. I want you to assume for the purposes of this question that the Kowalskis informed the physicians during this first week that they had a different type of medical treatment and did not want to move forward with the hospital's recommendations. Do you have an opinion based upon your background, training, experience, and to a reasonable medical management probability as to whether the hospital violated the second from the bottom on the first column to right to refuse treatment?
Objection, lack of foundation and relevance, Your Honor. Falls outside the pleadings.
Overruled.
Yes, I do have an opinion, and this right clearly states that you have a right to refuse treatment except that written by law.
Have you seen anything in these records or been told in any of your investigation that the Kowalski's decision to be treated, have their daughter treated outside of Johns Hopkins violated any law?
Objection, Your Honor.
Same ruling.
I've seen nothing to the sort.
Have you become aware that there was an incident where Maya Kowalski was placed into a quote surveillance room and told that it was some form of EKG when in fact she was being surveyed by the hospital?
Objection to foundation, misrepresentation of the record.
Overruled.
I understand that it was an EEG, electroencephalogram, not an electrocardiogram. And those rooms in pediatric hospitals, it's normal for EEGs to be videotaped. That's not a practice in an adult setting.
In this instance, did it come to your attention that no actual EEG was ever performed?
There was certainly no evidence of that on the videos, that they were performing an EEG. That would involve a lot of wires, and it would be very easy to see.
And assume further, for the purposes of this question, that there are no results, analysis, or barely mention of this procedure in the medical records surrounding it. Do you have an opinion based upon your background, training, experience, and to a reasonable medical probability as to whether, again, this violated Maya Kowalski's patient's rights to be able to move freely around?
Objection, Your Honor. Relevance, foundation, 403. It's outside the pleading.
Overruled.
You can.
She was placed in an EEG room and surveilled, but that apparently never made it to the medical records.
Correct.
Which would indicate to me that it was not part of the care and treatment of Maya Kowalski.
And so then, do you have any opinions as to why they were doing this?
Objection, cause speculation. No foundation. Overruled.
You testify.
It certainly wasn't to treat her and help her feel better, because it was never documented. Rule of thumb is if it's not documented, it wasn't done. As to whether they were trying to just observe her activities, her actions surreptitiously, that's as likely as any reason for it.
Would you expect in that circumstance for there to have been some documentation in the medical records, some discussion of results or observations?
Objection, lack of foundation. He's indicated he didn't review the record.
Sustained. Okay, I'll move on.
And Mr. Anderson, the next 7 minutes, let's bring us in for a good point for a break.
Yes, sir. I'd like to bring up Exhibit 3002-0002. And for the record, this is the consent for medical routine diagnostic procedures and treatment. May I publish, Your Honor? Present evidence 3002-0002. It's a defensive exhibit.
That's right.
It is.
It is, Your Honor. This was a carve out. It is request, I believe.
It's not in evidence. Either needs to get in evidence or you can't show it to the jury.
We don't object to it, Judge. It's not evidence from me. If you want to lose it, go ahead.
Well, then what's this number?
3002-0002.
Yeah, I'll receive that exhibit in evidence. Now you can put it up for grants.
Thank you. Now, if we could look at the second page of this, and you've got it up. All right. So in this, first, tell me, if you can, have you had involvement in either the development or the evaluation of these types of consents placed in the admissions packages of the patients before?
I've never developed a consent to treat. I'm certainly familiar with them as both in my professional life and as a patient.
All right, and so in this particular one, then there's a consent to treatment that involves understanding that imaging technology, videotapes, photographs, closed-circuit TV monitoring patient care may be used. You see that in the course of treatment?
During the course of treatment.
And why is that phrase, during the course of treatment, significant to any consent that the Kowalskis gave or did not give?
Objection to relevance, Your Honor.
Overruled.
So in the deposition this morning that that was shown of Dr. Perno, he said that the consent to treat.
I object to the comment about
Sustained.
You can just have to reference it. Just your opinion.
Okay, I apologize.
Go ahead. No, sorry.
It's been testified that the consent to treat gave the legal.
No objection, Your Honor.
Does this?
I'm sorry.
I'll rephrase. In your practical and clinical experience, is there a requirement that any such video or photographs have to be part of actual treatment in order for these consents to apply?
Objection to one. Calls for conclusion. Relevance.
Overruled.
Yes, it's clearly stated that videotapes, photographs, and closed-circuit television monitoring of patient care may be used during the course of treatment.
And so if the jury were to want to determine whether this consent had any validity, what would they want to look for in the medical records around the time of any such photos or video?
Objection. Foundation. Speculation.
Overrule those two objections.
At a very minimum, I would expect that the videos, photographs, etc., would be part of the medical record if, in fact, it was part of a course of treatment.
And would you expect there to be discussion or analysis of them as to the why, how, and result?
Same objection, Your Honor.
Overruled. You can answer.
Yes, I would expect that it would be referenced in a progress note. I would expect that there would be results or interpretations, just like any other test.
And so then let me bring up Trial Exhibit 2277-06. Oh, not. I'd like to move in Trial Exhibit 2277-068, part of the risk management file. It's actually just that first page. I think the two of them are complete.
may inquire, was this one of the ones that we discussed?
It looks like one of the ones we discussed, but can we approach that?
I'll tell you what, why don't we take a break? Members of the jury, do not discuss this case amongst yourselves, do not do the investigation and receive no information. Let's try to keep it to a 15-minute break, please.
All right, doors exit.
The juries of our presence, everybody can be seated. I believe that exhibit this.
I missed the question.
Someone can put the.
Oh, yes, 2277-068.
And sir,
Yes.
I need you to step outside.
Happy to, sir.
Transcript to reflect the witnesses leaving at the court's request.
Your Honor, if I go to the bathroom, I will.
You're fine.
Thank you.
So, what is this and how are we going to use it?
Your Honor, this is a risk management note from the hospital, and it is describing circumstances of the videotaping. It's unfortunately one of the exhibits we would have used our lunch break for, but we had other issues. So, pertinent to this discussion is that it relates to the October 18th to 20th videotaping in the EEG room, which was just discussed at some length. And at the bottom, you can see the various approvers, for lack of a better term. You have Dr. Sally Smith, Dr. Deese, and then pertinent to this witness's testimony, you have an authorization from RISC. It says okay from RISC. It describes, in particular, the videotaping, and then it says no order relevant to this witness's testimony that there would need to be a progress note, a result, an order of some type for this not to be a failure by the hospital. And then it explains the circumstances of the videotaping and the rationale relevant to the consent to treatment, which is the diagonal right in there at the bottom right says able to do when no one was there. So it's reference to, well, that's it.
Notice. Judge, we don't know who wrote this. We don't know for what purpose it was written. We don't know what these random cryptic notes mean. And this witness has testified that he's never reviewed the medical record to comment on what should be in the medical record or what is or isn't in the medical record. So I don't know what this is being offered for right now, but there's no foundation for it. There's no demonstration of who created it, for what purpose, under what circumstances, or for what intended result.
Well, let me ask you more fundamentally, because I know we've been discussing this particular issue for 2 years now. Is the hospital's position that this was a medical procedure?
Yes, sir. This was part of a diagnostic procedure. We said that from the outset.
Okay, so then what's it doing in a risk management file? I mean, this is from the risk management file, right?
This is from the risk management file. I can't tell you what this is doing in the risk management file, Judge. I suspect that they were asking if it was okay to proceed with that based on the consent that was in there, but I don't know that, and I don't know what this means. And there is evidence of physicians indicating that they wanted to do the EEG video monitoring.
And after 5 years, no one has claimed ownership to this note that happens to be in the risk management file?
We think we know. I believe it was the first lady. No, Condon. It was. I thought it was Mr. Condon. I thought it was Condon.
It'd either be, well, it could be Patty Conn, it could be Louise Burns-Kurth, but
Who cares? From our point of view, it's a risk management. It's from the risk management file. It states there's an okay from risk management. It identifies people involved in it. And we're putting it in for the purposes of demonstrating exactly what the court just brought up, which is if this is supposed to be a medical procedure, why is risk management bringing in Sally Smith? Why is risk management bringing in Dr. Dees? Why is risk management involved at all if this is a fairly routine treatment or procedure?
Let me just make it more fundamental. Obviously, this is a hearsay document, but it is a statement by the hospital.
Correct.
So there is an exception to it. So there is a basis for it. It clearly is relevant, extremely relevant. So I don't see how I can keep this out, Mr. Hunter. I mean, what other basis are you suggesting that I exclude this document?
There's no indication of what the document means, of who created it, or what the intention behind the so-called document is. I would venture to the comment that saying that this page of random notations is a document is stretching the word document a bit far. It came from the risk management file, I'll grant that, but the idea that it simply reflects someone having called risk management and been asked, is this okay? And been told, yeah, that's not, number one, it's not relevant to particularly anything other than the fact that it occurred. And number two, it doesn't give this, with these random jottings, any kind of probative value or relevance.
Well, here's where I'm just not following your argument. Because this has been one of the most hotly contested issues in this case. And you're telling me that a document from the risk management file, and that's one of the punitive damage claims, talks about the video, no audio, no order, to see if she can walk on her own, suspected Munchausen syndrome by proxy, that this is not relevant? I mean, how is that possible, Mr. Hunter?
Judge, the doctors were attempting to gather clinical information. There is a notation in the chart, patient transferred to room 709 yesterday for monitoring, continues to have pain all over, but reports she was able to get more sleep last night. Her PO intake appears to be slowly improving. The demonstration is from that note that it is part of the medical record, and exactly the narrative that's being promoted is just not correct. We don't have a date on this beyond what 1, 2, 3, 4, at least a range of 6 dates. So we don't know what it was for.
Well, the jury's going to get to see it. Highly relevant. I don't understand why we continue to talk about it. We've been talking about it for years. This is highly relevant. And
Yeah.
I mean, I guess yours and my definition of relevance isn't calibrated the same. So
Assuming it's relevance, it doesn't speak for itself. So to give it to an expert to opine on before the person who actually put it in the record and can explain its contents, when, where, and how, and why it was done, I mean, this is just the wrong time to use this document.
Now that I am more akin to that type of argument, Mr. Altenberg, but it seems like this document is pretty clear as to what it means. So I'm going to go ahead and admit 2277-068. Can we take a break?
Yeah.
Okay, we'll be back in 10 minutes.
Your Honor, at least when this witness is concluded, I want a special instruction on the fact that violations of internal rules and policies and things like rights and responsibilities is not a violation of the law or actionable, but it can only be used as evidence. We need a limiting instruction on what's going on here.
Absolutely. Well, I suggest you, on the break, get Mr. Elliott on the phone. You and he start talking about this. Okay. Thank you.
All rise. Court on recess.
Be seated.
Okay, members of the jury, I just want to confirm while you're away, you did not discuss this case amongst yourselves. You did not do any investigation, and you did and you received no information. Is that all correct? And has anyone approached you about this case? And have you seen any media coverage about this case? No. And the doctor's taking the stand again? You can. And you understand you're still under oath, sir?
Yes, sir.
Okay. Mr. Anderson, you may continue.
I'd like to pull up Trial Exhibit 2277-068. That in? Yeah, that's in. That's the one we just got in. 2277-068. All right. Now, Dr. Corcoran, I'd like to orient you to a few phrases here. And the center bottom of the page here, there is an inscription that says, okay from risk. And then and we can highlight that. Now, based on your experience and knowledge, and I'll represent to you, this came from the risk management file. Does this appear to be a form of authorization from a risk management department, given the circumstances?
Judge, conclusion, lack of foundation, relevance.
Overruled. You can answer.
I don't have enough information to make that conclusion, sir.
Assume for the purposes of this question that in fact is a risk is referring to a risk management department. All right. So if you then look up in the top right hand, it says to see if she can walk on her own. Do you see that?
I do.
And then above that, it points and says something to the effect of no video.
Apparently in the PICU.
Right.
Right.
And then below that, it says video only, no audio.
Correct.
Right. And then if you go down here, in this box on the lower right, able to do when no one was there, I believe. And then finally, on the bottom left, it says no order dash and above it videotaping. And I'll represent to you that this is from the risk management department. Now, based upon your background training and experience, does this appear to be an analysis of a medical need or an analysis of another need to prove something, a diagnosis or whatever?
Connection, lead, relevance, foundation.
This does not look like a traditional order, which would be electronically submitted in an electronic medical record. This looks like notes taken. You said it's from the risk management department, so I would say that these are notes taken of a briefing or a meeting where it's decided based on this history, based on this need, we have the okay from risk to do videotaping without an order.
And then in the center of it, it says suspected Munchausen syndrome by proxy. I know you're not a psychiatrist or psychologist, but are you aware of whether suspect Munchausen syndrome by proxy is a diagnosis of a parent or a child?
Yes, Your Honor. Foundation, confidence, relevance.
What, if anything, do you know about Munchausen syndrome by proxy?
Stand objection. It's beyond scope.
And finally, I'll point out here in the center above, it says Dr. Smith, Sally Smith. Do you see that?
I do.
And Dr. Dees and Dr. Smith, Sally. See that?
I see that.
And have you seen in the records where these two doctors were participating in the ordering of this video?
Objection to foundation.
Asking if he has.
Overruled. You can answer.
I have not seen that specific order, but I have seen both doctors referenced throughout the stay.
Okay. And have you had an opportunity to investigate, as part of your the assignment here, the role of Dr. Sally Smith in all of this?
I have.
And did it come to your attention that Dr. Smith was the director of child abuse education at Johns Hopkins All Children's Hospital during the relevant period of time?
Objection to relevance foundation.
Overruled. You can answer.
I believe that she was head of that program from 2015 to 2018, if memory serves.
And let's pull up Exhibit 2116. That's in evidence, Your Honor. That's for the committee, I believe. Messages. Now, if you take a look there with Dr. Smith, does it appear Dr. Smith and Dr. Paola Dees were messaging back and forth?
It does.
And so it says, FYI, we were able to move her to a video room last night. Staff has been making notes by watching her remotely. Apparently, she's currently sitting in bed with legs crossed and has a laptop or something propped up on her lap.
Objection to leading.
You see that where it's written there?
I do see that.
Oh. And I'll ask you to assume, for the purposes of the question, that the videotaping in question occurred October 18th and 19th, 2016. And then below it says, we may need to try to monitor what she's doing online. I wouldn't put anything past her mother.
I see that.
Objection, Your Honor. Reading the document speaks for itself.
It's a predicate. So, if this type of communication was brought to your attention in your roles as director of, again,
chief medical officer,
where two doctors were conversing in this manner about a patient and a patient's mother, what, if anything, would be your concern?
Objection, Your Honor. Speculation foundation relevant.
At a minimum, I would address their method for discussing the case and the tone and characterization of their discussion.
Does this tone and characterization, based upon your knowledge and position, both as a physician and as a medical director, does this appear to be a compassionate concern for a little girl?
Objection, foundation, relevance, leading, speculation.
Overruled.
In a word, no.
And should doctors be trying to set up their patients to see if their symptoms are correct or not? Or
I'm
real
sorry?
Or not? Should doctors be trying to set up their patients to develop, for lack of a better term, evidence or proof against them for their diagnosis?
Objection to relevance, 403.
Can you, Mr. Corcoran, can you re-ask that one for me?
Should doctors be trying to set up their patients to develop, for lack of a better term, evidence or proof against them for their diagnosis?
Sustained.
I'm going to leave that be for now. I'd like to pull up 2277-630 and 631A. This is, for the record, an email between Patty Condon, who I'll ask you to assume for the purposes of this question was one of the risk management personnel.
So the transcript clear, we're looking at 2277-630A, not
A.
Yeah.
Did I say 8?
I think you missed the A.
Yes, sir. Thank you, Judge. Now, I'll also ask you to assume for the purposes of this question that Louise Burns Kurth was the chief, I guess, of the risk management department. And I'll ask you further to assume that this involved a transfer or a discussion of a transfer out of the hospital. And finally, I'll ask you to assume that the Kowalskis would like to get the child out of the hospital, but refuse to do it to a psych patient, inpatient program, any type of psychological or psychiatric program. Now, can you tell the jury whether this type of attitude, as expressed here in this email, is indicative of a close relationship with the patient and her family to work together for a transfer, or whether this was more of a antagonistic relationship?
Objection, relevance, leading 403, assumes facts not in evidence, improper hypothetical.
Can I have that one again? Word.
Also beyond the scope of the pleas, Judge.
Now, can you tell the jury whether this type of attitude, as expressed here in this email, is indicative of a close relationship with the patient and her family to work together for a transfer, or whether this was more of an antagonistic relationship?
What, if anything, does this email tell you about the risk management position on Maya Kowalski being transferred out?
Same objection, Your Honor. Condition begged.
You asked about a relationship between the patient and the family. I believe you meant the caregiver and the family?
Yes.
This looks more antagonistic than collaborative.
And are you familiar with the problem of a medical narrative starting in a hospital about a patient or situation?
Objection, Your Honor. Relevance 403, beyond the scope of the pleadings, and I think it's assuming facts not in evidence.
What, if anything, have you experienced in terms of a narrative, that is a story based on a selection of facts and ignoring other facts to prove a point or make a point through the course of your experience in hospitals?
Same objection, Your Honor. In addition, he's used the prior question to suggest an improper question to the witness.
Can we scroll down, please? So, I think I'll live with the last answer. Let's proceed. Now, can you help?
It's 2142.
2142, you want to publish?
It's in evidence?
It is.
Yes.
If you could review this and see if whether Dr. Sally Smith appears on here.
She's not listed on the Standards and Credentials Committee four names down.
All right. And did you have the opportunity?
I agree with it.
With what?
I agree with it. We don't need him to basically read the document.
I understand, sir. I just wanted him to identify that she was on there. Now, did you have the opportunity through your investigation to try to determine the role of Sally Smith in the care and treatment of Maya Kowalski?
I did.
And what did your investigation reveal?
Objection at Frederick Fleck Foundation, Your Honor.
You can.
So Dr. Smith was head of an outside agency, but had an internal.
I'm going to sustain the objection.
Okay. What, if anything, did it appear to you in reading through this as to Dr. Sally Smith's role at the hospital?
Excuse me, I object. I don't know what he's reading through. I don't know what's being asked.
I assume you're talking about the committee list?
Yes, her overall role at the hospital based on what we've already.
For a second.
I'd like to publish then 2045-005. This is a statement. Actually, is this in evidence?
Yes.
All right. May we publish, Judge?
If in evidence, yes.
All right, I'd like you to review that statement to yourself, please, Doctor.
Thank you.
Do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether, based on your review of the facts of this case, Johns Hopkins All Children's Hospital lived up to or complied with the statement by Dr. Mueller?
Objection, Your Honor. Relevance, foundation, lack of predicate, and 403.
Sustained.
What, if anything, did you see in this organization to indicate that there was a defined chain of, that there was a defined leadership or lack thereof?
Same objection, Your Honor.
To overrule that objection, you can answer that.
So it's the indications have been consistent that quality assurance and performance improvement was to be organized at a division level. And the divisions report up to departments. There appeared to be no system-wide approach to quality assurance and performance improvement.
What's the problem with that?
Well, for start.
Objection, Your Honor. It's vague. It's calling for a narrative answer. It's calling for a lecture. It's outside the pleadings. It's 403 violations of law.
Overruled. You can answer.
So first, it's an expectation that I was held to every time that I was at the facility or division and participating in a regulatory survey, that we could demonstrate a system-wide approach.
Why is that better?
Well,
You can answer.
it sounds great to have everyone responsible for quality and patient safety. But we've all experienced it that when everybody is responsible, nobody ultimately is responsible. So without oversight by a leader like a VP of quality, a VP of medical affairs, a chief medical officer, somebody to make sure that there was a consistency, you had wide standards from one division to the next, and that creates gaps where patients can fall through the net. And this, my experience in reviewing the system that the leaders have addressed and touted, is that this was really a system-wide failure that allowed Maya and potentially others to fall through the gaps.
Do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether the system that was set up by Johns Hopkins All Children's Hospital in operation provided sufficient safeguards to protect children in Maya Kowalski's position?
Objection, Your Honor. Foundation, relevance 403, improper hypothetics.
Sustained.
What, if any, opinions have you formed about the ability of the system you just testified to protect children who are in a situation such as Maya Kowalski was during October of 2016 to January of 2017?
Same objection, Your Honor. We're saying the same question.
I agree. Sustained.
What changes, like that, how would this system have to be changed, in your opinion, in order to ensure that situations such as a child being allowed to, or being photographed without authorization on 2 occasions, a child having what we discussed before with the not being allowed to see her priest, having things taken from her, these type of events from happening?
Objection, Your Honor. Relevance 403, leading. It also fails to take into account DCF and Chapter 39 involvement, and it's outside the plea.
That's
Overruled. You can answer that one.
So the quality assurance and performance improvement function would need to be overhauled so that it was system-wide. And that's actually something that Hopkins is recognized as a leader in. So the expertise should be readily available to the team at Johns Hopkins All Children's Hospital. But that would provide a consistency from division to division, and create a safety for patients as they're being handed off from one caregiver to the next.
Do you have an opinion based upon your background, training, experience into a reasonable medical management probability as to whether the system in place provided sufficient safeguards for children at Johns Hopkins All Children's Hospital during the relevant period?
I do have an opinion.
And what is that opinion?
Objection, Your Honor. Relevance outside the pleadings, improper foundation.
But I don't think you tied it to Maya Kowalski, so I'm going to sustain the objection.
Same question as to the care and treatment of Maya Kowalski.
Same objection, judges. The question's compound as well.
I'm going to overrule that. You can answer it.
I do have an opinion.
What is that opinion?
I do believe that the system failed Maya Kowalski
and her family during her stay, primarily because the architecture was so siloed that there was no, there were gaps in the safety net that let her care fall short.
Your witness.
Good afternoon.
Good afternoon.
Once again.
Yes, sir.
Your Honor, if the court please, could I first approach the witness and ask to look at the materials he's reviewed? Yes. You have a moment, Your Honor?
Sure.
I'll get this back.
No worries.
Honest. Okay. Thank you, sir.
Yes, indeed.
If I understand correctly what you just shown me, and what I will ask the clerk to mark when we get through here was a complete list of everything you've reviewed about this case. Is that right?
It is a list of everything that was provided to me. Yes, sir.
Okay. And it was provided to you grouped in grouped by issue. Is that correct?
By date and by issue.
Yes. So in other words, if they wanted you to look at issues relating to the surveillance video, they sent you documents regarding that, correct?
That is correct.
And if they wanted you to look at corporate documents, they sent you a group of documents related to that, right?
That's how they're grouped. Yes, sir.
Okay. And if they wanted you to look at examples of Dr. Smith directing care, they sent you a group of documents relating to that, right?
Yes, sir.
Okay. And then if they wanted to have you look at particular documents regarding the surveillance video, they sent you documents related to that, correct?
Yes, sir. That's one grouping.
Okay. So do you have any idea how many pages of policies and procedures and documents have been produced in this case?
Have been produced to me?
No, sir. To the
In
parties.
jail.
That the hospital has produced.
I understand
The
that there.
plaintiffs have produced. Got any idea?
I understand the number is in the tens of thousands.
Okay. We can agree, can't we, that you didn't get tens of thousands of documents?
No, sir.
You didn't come anywhere close.
And for the scope that I was evaluating, I didn't need the entire.
Well, so that we're clear, we covered this a little bit earlier, and I'm not going to go back into what I asked you before, except perhaps by accident. But you're board certified in osteopathic medicine, but you've never held yourself out as a pediatrician, correct?
I am board certified in obstetrics and gynecology. I have a grad.
I'm sorry. I beg your pardon.
No worries, sir.
You're an osteopathic physician.
I am an osteopathic physician.
And you're board certified in obstetrics and gynecology.
Yes, sir. That's correct.
And you've never been trained as a pediatrician.
That is correct.
And you've never held yourself out as such.
That is correct.
And as far as your opinion in this case, it presupposes that the diagnosis of CRPS for this young lady was correct, doesn't it?
No, as I explained to you during my deposition, it presupposes that the proper approach should include an evaluation for CRPS.
I see. Okay. Did you ever look at any records of this young lady's care from Lurie Children's Hospital?
Not from the hospital, no.
Did you ever look at any from Tampa General Hospital?
No, I did not.
Did you ever review any complete medical record in this case?
Medical record? No.
Okay. And the depositions that you seem to have reviewed in this case, looking at your list, seem to be somewhat limited. Is that right?
Yes, sir. I think that's fair.
Okay. Well, you reviewed Sally Smith's and Ms. Beatty's and Dr. Elliott, Ms. Condon, Ms. Crane. That's about it, wasn't it?
No, sir. Dr. Perno.
Okay, Dr. Perno.
Dr. Napolitano. There were others.
There were others. Did you ever review Dr. Michelle Smith's deposition?
I don't recall that name.
Okay, well, that's a good thing because she wasn't deposed. Here's what I meant to ask you. Did you ever review her progress notes from the PICU?
I did not.
So you have no idea what efforts were made to transfer this patient during the first week that she was at All Children's?
I didn't review the medical record references to transferring the patient.
Okay, so you don't have any idea what they contain?
I never reviewed the medical record, so I have no insight into what was in the medical record regarding the transfers.
Okay. Now, let's go back to what you haven't looked at. Did you ever look at Dr. Hanna's records? Ever see his records at all?
Not his records, no, sir.
You never saw Dr. Kirkpatrick's records?
Not their treatment records.
Okay. And you've never seen any order in the chart regarding the EEG video or seizure monitoring, have you?
Again, I have not reviewed the medical record because that's not the area of expertise that I've been brought to assess.
Well, you've expressed some opinions regarding the EEG video. What I'm trying to find out is, have you looked at the chart to see what's in the chart about that video?
I don't think that reviewing the charts are necessary to inform the opinion that I shared a half hour ago.
Okay. But you did indicate in that opinion what you thought the chart should contain, right?
I was asked to review a memo. I shared my opinion or insight about that memo.
Were you ever provided any of the court orders regarding this patient?
I don't specifically recall seeing the court orders. I may have, but I don't recall it right now.
Going back to Ms. Beatty, did you ever see her personnel file?
No, sir.
Did you ever see any of the evaluations that she had, her annual evaluations?
Annual evaluations? No, sir.
Okay, so you have no knowledge of any of that?
Of her annual evaluations? No, sir.
Okay. And with Dr. Mueller, the VPMA, you know who she is?
I do.
Did you ever see her job description?
No, sir.
You did notice on all the charts here that there was no title called Chief Medical Officer in their lexicon.
And I pointed that out.
Okay. So you're kind of assuming where the Vice President of Medical Affairs fits in? You don't really know what her
I don't agree with that characterization at all.
Well, you don't know what her job description is, do you?
The job description wouldn't be on the organizational chart anyway, but you are correct.
The organization.
I've never seen her job description.
Okay. So you know where the line is. That's about all.
It wasn't represented, so I don't know where that line is, and that was my point.
You don't know where the line is, and you don't know where she fits in.
On that chart, you are correct.
Okay. Well, you looked at several charts, didn't you?
Well, I looked at organizational charts that were provided that apparently were from 2012, which had the position listed.
You talked about the consent. Council put up 3002-002. Had you ever seen that before?
Not before getting involved in this case, no.
Okay. Well, there was a question about the use of images, video in this case, in the course of treatment, correct?
Correct.
Diagnosis is part of treatment, isn't it?
I would think so.
Okay. You'd agree with me about that, right?
Sure.
Okay. With reference to transferring this patient, were you ever aware of Ms. Kowalski denying that she wanted to take Maya out AMA? Were you ever made aware of that?
My understanding is that the objection that she had was based on the diagnosis of a psychiatric disorder.
I understand. So your understanding was she didn't want the child transferred because the child would carry a psychiatric diagnosis upon discharge. Is that right?
I think we heard that that they didn't want to accept that as a transferring diagnosis.
Did you ever see any indication that the hospital was asked to reconsider that part of the medical record?
Again, sir, I've not reviewed the medical record.
Okay. No, well, my question wasn't really restricted to that. My question was, did you ever see any indication that this family heard, gee, you're going to discharge our daughter with this diagnosis. We want you to change the diagnosis. Did you ever see any documentation of that?
Where would that documentation be?
Could be any one of 1,000 places. I'm asking you whether you ever saw that suggested.
Only in testimony.
You heard it in testimony somewhere?
I believe we heard that Monday morning.
We heard that someone asked to change the diagnosis?
No, we heard that the diagnosis was rejected.
I understand that.
Okay.
Listen to my question very carefully, please. Because it's probably confusing, even to me. I confuse very easily. But here's my question. My question is, did you ever see any indication, any documentation, any indication that this family asked that diagnosis for Maya's discharge that they didn't like, that it be changed?
Documentation? No.
And under the client's rights you talked about, they had the right to do that, didn't they?
I don't have the document in front of me, but if it's in your hand, I have no reason to question you, Mr. Hunter.
Okay. I appreciate you having a chat with my wife.
Only if you'll do the same, sir.
Okay. Deal. Were you aware of any policy at All Children's regarding images and recordings of patients in child abuse cases, child abuse situations?
Can you cite the policy for me?
I can. It's Defense Exhibit 3019-005. Did you ever see that?
Visible? Off the top of my head, I can't tell you.
Okay. Well, I'm not sure it's in evidence, so I'm going to pass along with it right now. But that brings me to another set of questions. In your experience as a CMO in Florida, have you ever worked with DCF?
That never came across my desk.
Objection.
Sustained.
Very well. Did you you told us that you had no role in preparing any consent of the type we talked about earlier. Is that right?
I never wrote the consent. We left that to the lawyers.
Didn't I understand your testimony to be that the medical staff is independent of the hospital?
The American Medical Association was granted autonomy around the time of the adoption of Medicare. So, yes, the medical staff is meant to be self-governing.
Okay. So the mere fact that someone holds a position in the medical staff doesn't necessarily reflect any position with the hospital per se. Is that right?
I disagree with that.
So you don't agree that the medical staff is independent of the hospital?
I don't agree that anyone with a position of authority, regardless of who they're aligned with, can't hold a position of influence with a hospital. A board member, a politician, a community leader.
Like yourself?
I'm neither. None of the above, sir.
Well, you were elected president of your medical staff.
I was and unable to serve, but that was when I was in practice. That was a long time ago.
But if you had served,
yes, sir,
that would not make you an employee of the hospital, now would it?
That's correct.
Let me ask you about a couple of depositions just to be on the safe side here. You've never reviewed any of the Kowalski's depositions, have you?
I have not.
And you've never reviewed the depositions of Dr. Kreisman or Dr. Kilgore?
Kilgore, I have not.
Dr. Posey, Dr. Sanchez?
I don't believe it. Off the top of my head, I can't comment about those.
Okay. Well, let me ask you about Dr. Tepa Sanchez while I've got you on the subject here.
Okay.
You talked about, you referred to the text exchange between Dr. Vos and Dr. Tepa Sanchez?
I believe that was brought up.
Okay. Do you know who Dr. Tepa Sanchez is?
From the PICU?
Yes.
Yes, sir.
You know what dates she saw this patient?
Not off the top of my head, sir.
Were you aware that she hadn't seen the patient for nearly 3 months at the time that Mrs. Kowalski committed suicide?
Well, she was a PICU physician, and Maya was in the PICU in the early days of October, and that unfortunate message was exchanged, 3 months later in January of the following year.
I think maybe she was referring to what she did 3 months before, not what the hospital did during the ensuing 3 months.
Can you read the text for me so I can put it into context?
I've been objecting to that, so I'll tell you what, we'll let the jury hear that from her.
Okay.
But the point is, you never heard from her what her explanation was for what she meant in that text message, have you?
I've never spoken with her, no, sir.
Okay. That's all I have. Thank you, sir.
Thank you, Mr. Hunter.
Mr. Anderson, do you have any follow-ups?
Did counsel here show you a single document, deposition entry, or any other evidence that changed your opinions in any respect?
No, sir.
Nothing further.
Anything further? Members of the jury?
Do you need me to step out, Your Honor?
It depends. See how many questions I get.
Yes, sir. I'm learning.
John. Got what? I'm sorry, what for?
Well, Doctor, why don't you go ahead and step down? What if you,
Could we mark his list while he was counting?
that's
Let's take this video off.
stepping out, sir. Thank you. Members of the jury. Oh, no, this goes to the chair. I can say it. Members of the jury, why don't you step into your room back there? Do not discuss this case amongst yourself. Do not do the investigation and receive no information. All right, so we're back to policy. Through these questions, red one.
Handicap, who asked them?
No, let's just get through this. And what's the name of the witness again? Dr. Corcoran. Okay, the first question is Dr. Dees and Dr. Smith still at Johns Hopkins All Children's Hospital? If not, why? Any objection, plaintiffs? No. I'll ask that one. Next one has a couple of questions. If parents have ongoing concern regarding their child's daily care and treatment at the hospital and expressed it often to the staff, would the parents be advised as to the proper chain of command they should contact to voice their concern? The next question, were the Kowalskis told, I think it's they, could contact senior executives to voice their concern via email, Dr. somebody. Next question is, I'll put an underline so you can tell me the name of that doctor. Next question, if medical staff works independently of the hospital, then who I don't know that word. I think it might be told them, or who holds them accountable? Who holds them accountable?
Who holds them accountable? Looks like the name.
It's called.
Yeah. But I don't know about the name of the doctor in that second question.
The second question? Well, but it's via email or other.
Or otherwise?
Yeah. I don't think it's a doctor's name. I think it's or otherwise.
Or otherwise. Okay.
We're objecting number 2 is on the basis of foundation. It hasn't been moved. And
Mr. Anderson? No objection, and if he knows, it's number 2, which I think he might, is Mr. Kowalski's testimony. He can testify.
Okay, I'm going to overrule the objection to number 2 on red number 2. So I will ask it. Okay, red number 3, there's several questions. Do court orders have an effect on a patient's family rights? If a child is in custody of DCF, do the parents have the rights to consent or deny treatments during the DCF custody? Have you assisted in a case with a Munchausen by proxy diagnosis in your career? I'm assuming the first 2 are ones that ultimately I'm going to give legal instructions on and are not appropriate for the witness.
Agreed.
So that leaves us the question about, have you assisted a case with a Munchausen by proxy diagnosis in your career?
Well, he's not being tendered as any kind of medical expert, so I don't know what matters that he answers or not.
It doesn't matter to me, Judge.
So either there's an objection or there's no objection.
Objection.
No objection.
Okay, I'm going to overrule the objection and ask. And I think the last page. What is, quote, the acuity of the bed, end quote? Please elaborate, what does this mean? During defense review, the question was regarding the acuity of the beds.
Yep.
Not sure what that word means in this question. I'm sorry?
Yeah, it's probably myself, Judge. I'm sorry. Bemoaning the fact I didn't define that.
So did you answer yourself if you were asking yourself the question?
Pretty much.
Okay, so no objection? Is that, Mr. Anderson, no objection?
No.
Okay. Before we bring the jury back, I'm assuming this is our last witness today.
I could probably get GAL. Oh, too bad. Yeah. Well, that answers that. That was our last.
Okay. So sounds like this is our last witness. I'm going to tell the jury 9 o'clock tomorrow. Is that what we all decided?
Yes, and then we'll start with the video depots, and then
The Georgia.
Why don't you get the guardian ad litem up and down and then do this? What's up to you, Mr. Anderson?
If she wants to get back, if she wants to get home, she's going to want to go first.
yeah, I was just trying to take off tomorrow morning to get those exhibits together. Yeah, we can call her first, and then
We can talk a little bit.
Let's bring back the jury.
Yes, sir.
all
right, jurors exit.
Can we get it?
I was already seeing this, I said.
Everybody. Members of the jury, just want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And I want to confirm that you've not been approached by anyone about this case since you were last with us. And you did not see any media accounts. Is that correct? Okay, Dr. Corcoran, the jury has several questions. First question, if you know, is Dr. Dees and Dr. Sally Smith still at Johns Hopkins All Children's Hospital?
I don't know for certain. I understand that Dr. Sally Smith has.
If you know or not.
I don't know.
Thank you. Okay. Next question. If parents have ongoing concern regarding their child's daily care and treatment at the hospital and expressed it often to the staff, would the parents be advised as to the proper chain of command they should contact to voice their concerns?
That's a very reasonable expectation, and I believe that that's the way it should work. I can't say that the system in place in 2016 provided for that.
Were the Kowalskis told they could contact senior executives to voice their concerns via email or otherwise?
I don't know the answer to that.
If medical staff works independently of the hospital, then who holds them accountable?
That's a great question. And the Medical Executive Committee, which I was a member of for 4 years when I was in practice, is responsible for oversight of the physicians for quality assurance, performance improvement. And the Medical Executive Committee has a relationship with the board of the hospital so that everyone's on the same page. I hope that answers the question.
The next question, and for the author of this one, I'm only able to ask one. Have you assisted in a case with a Munchausen by proxy diagnosis in your career?
I have not. I practiced obstetrics and gynecology, and I'm happy to say that that was not part of my experience.
Next question. What is the acute, quote, the acuity of the bed, end quote? What does this mean?
That would be a better question for Mr. Hunter, but I believe that he was referring to how sick of a patient can you care for? Some hospitals, like Venice Hospital when it was around, was a lower acuity. Sarasota Memorial Hospital takes care of sicker patients, so it has a higher acuity.
Mr. Anderson, that completes the jurors' questions. Do you have any follow-up questions?
No, sir.
Mr. Hunter, do you have any follow-up?
No.
And may this witness be excused.
Please. Although he's still under.
Okay, so you're free to go today, but you still might be called back. Okay, have a good day. Okay, members of the jury, I think this is a good point for us to stop the witnesses for today. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. 9 o'clock the same time. We will see you tomorrow.
Thank you.
Have a good day. Everybody. Do the shot clock while I'm thinking about it. Okay, the plaintiffs consumed 3 hours and 20 minutes today. Their running total is 36 hours, 10 minutes. The defense consumed 40 minutes today. Their running total is 12 hours, 50 minutes. Are there any issues we need to address before we?
Well,
Just to be helpful, Judge, there were a couple of objections on the Dr. Newberger's that you had some question marks, and if we could look at those so we could get rulings on those.
Sure, and I think
have a
part of
copy
it.
for you.
Okay, that's great, but I think maybe it was a missed site or.
Well, I think it's just the way they designated it, Judge. So, Nick, can you mind looking with me?
Sure.
Okay. So on page 3, you had a question mark of your order. I'm sorry, of your,
So this is the
It's
September
actually-
22nd, 2020 deposition. And you bring up page 145.
yes. So I have a copy of that page of the DEP, Judge. I meant to object 145-15, the word indeed, through line 21.
This isn't the right one.
So if I could, and my objection was breaching standard of care regarding Dr. Smith's role as investigator.
So you're suggesting that the lines 13 through 15 before indeed are okay by you?
Well, can I see it again, Judge? I don't think I objected to it. It was all where. My objection starts with the word.
Yeah, I will sustain starting at the word indeed at line 15 on page 145 through line 21.
Okay.
Okay.
And then the other one has to do with plaintiff's designation. You questioned on page 4. It's the September 30th, 2020 deposition. I went back and checked. They did designate page 183, line 1 to 12, which doesn't have a question. That's what they designated, Judge.
Okay, so what I put on here is I would overrule if the correct page site. So.
Well, I have the deposition for you on if you want to look at the page, but the line 1 is hanging there. There's the page before it's not designated.
Which is why I added
Right.
a question mark.
Oh, it looks like we failed to designate. We would designate the last word of the question, but we failed to designate
The question
the
began.
question beginning at page 1.
I'm okay with the question because I remember last night going back and looking at it. And,
Okay. Can I look at it real quick, Judge?
Sure.
So you want to start on page 182, line 23? Is that what you're saying?
Yes.
Okay. And then, did you want line, can I ask counsel? Did you want line 12? You designated
No,
line
that just
12.
looks to be
Okay.
sloppy highlighting.
Okay. No, that was your designation. I went and checked.
Sloppy highlighting translated to a designation.
Okay. All right, understood. I think those were your only 2 question marks, Judge. Let me just check real quick.
maybe I should just put an S or an O.
No, we can read sustained. But it might help your time. I do no such comment. Okay. Yes. All right, thank you, Judge. That was the only question marks I saw.
Any more designations coming anytime soon, or?
I don't think so. I don't think so.
So just to confirm, counsel, tomorrow, Dr. Newberger by deposition, Dr. Smith by deposition, the guardian ad litem. Anybody else?
Are we doing a half day or a full day tomorrow? I didn't know the outcome of that discussion.
Whatever you decide, but we just need to know on the defense side. Please no surprises.
I am looking to both sides. I will do whatever you all want to do, so long as you can agree.
Get the depots on the way in the morning, we can work in the afternoon.
Mr. Richards, and you'd have Debbie.
Yeah, we can take tomorrow afternoon off. I'd be able to get her in the morning, considering how long are those depots? I wouldn't mind taking the afternoon off, and we'll get absolutely as much in as we can in the morning. Maybe take a late lunch.
Okay, so
Keep through.
So, oh goodness. I'm not going to be able to have you in tomorrow until 8:45. So we won't have the ability to have any lengthy discussion. But I guess if you're playing a whole bunch of depths, it doesn't really matter. So we'll start tomorrow at 8:45.
Yes, sir. Hear that? We're starting at 8:45.
And to be clear, Judge, my understanding is the first two Newburgh depths are being read in. There's only the video for the last depth.
I think someone said that there was no video for depths 1 and 2. So
That's what I'm saying, Judge. Those are being read in.
That's true. We'll have to read the first couple.
Well, I'm sure you'll have readers.
So it sounds like that's the plan, just those two depositions and the guardian ad litem, and then.
So did you want to, because for a while you were talking about putting Maya and Jack Kowalski back on.
I think Thursday.
Tomorrow is Thursday.
Okay. You know, I can't take it off. We've got to put them on because we've got the damages people the next morning, Friday morning.
Okay, so tomorrow will be a full day, and then is it Jack Kowalski and Maya Kowalski coming back, or just Jack, or?
It's all three. But they're
all three, meaning Kyle as well?
Yes, Your Honor. But it's simply limited to the general damages, although I would like a stipulation of some kind about the liens, so I don't have to get into that with him. I will if there's no stipulation. I'll try to work out an instruction.
Your Honor, the difficulty on the liens is, that they want an instruction that basically tells the jury that they will owe the liens, if a verdict is entered. And one of the liens, which is about $10,000, appears to me to be a straight Medicare or Medicaid lien. Medicaid. And I know that they always maintain, well, we get it no matter what. The judges normally say you get it only if there's an award of medical damages on the verdict.
But wouldn't I have to do, is it an all-born hearing on that?
That's why we normally put this off to the end to let the judge decide, because mostly it's legal resolutions based on things. The second one is an insurance policy claim. I've not seen the policy, and it's not like it's a hospital lien or a statutory lien. It's something out of a contract. And even then, normally these things get negotiated or resolved afterwards to lesser amounts. So
is it an ERISA plan? Is that even further complicates it?
I don't know the answer to that.
Judge, we don't know whether it's an ERISA plan, whether it's a lien, or whether it's a right of reimbursement or a right of subrogation. And all that makes a difference. And
there's an LOP and there's two liens as far as I know. And I believe, don't quote me on it, but I thought Jack Kowalski said he paid either by mistake or just paid down part of one of them. The only thing I'm interested in, Judge, is that I don't get a DV on damages as to that, because a contingent liability like that is still a damage. And so if counsel is willing to go with that, then we can save all that till the end.
I'm willing to resolve the liens at the end of the case like we do in every other case.
What I'm hearing him say is that you would not move for directed verdict on that they failed to present
that
the
special medicals.
The damages.
And on the claim for fraudulent misrepresentation of the bill, that's what we're talking about, right? Is that claim?
Right, yeah, that's what it is.
Yeah, I might move for DV on a bunch of other issues, but not on that.
So it sounds like we have the beginning of an agreement here.
Yeah, I won't move for directed verdict on that count because you don't prove that stuff up. I absolutely will not.
All right, so I don't have to put in the liens for damages, for proof of the fraudulent,
Right, and
Right.
for the record further, I don't think you need to put that evidence in for proof of any of your other claims, but maybe we may still need
Mr. Hunter seems to have a
maybe not.
dissenting opinion.
I have an issue.
While they're talking, Mr. Anderson, I would imagine the cross will be relatively short if it's truly damages and we're not rehashing causation and liability, so we should be able to get through that schedule.
No.
Anyway.
I have nothing planned in terms of anything other than how did this affect?
I assume that, and assuming that's true, the cross will be short.
And what is it across?
If ultimately we decide not to call somebody tomorrow, can we just send a note to the other side?
Yes, please. And thank you.
Okay.
Even if it's at 10 at night.
Okay, so going back to our possible agreement here, you've conferred with Mr. Hunter.
Yeah, I'm not going to move for DV because they don't have proof that they paid that. And right now, I don't think they have proof that they paid anything else, but I won't move for DV on that either for purposes of that count.
Okay. So are we both sides agreeing? We have a court reporter here. We're in open court. So is that an agreement?
Yes, as I understand the defense's agreement, they will not move for a directed verdict based on the element of damages, since the majority of our damages has to do with the liens, which should be resolved, should not be put before the jury, and should be resolved afterwards. Based on that stipulation, I will agree not to approach the issue with my client as to the two liens and LOP, I believe it is. Are we in agreement?
And I concur in the agreement.
Thank you. So let's move on to the next issue.
Concern here?
No, I was just going, I thought we were done.
We're finished with that issue.
I was just going to rebroach. I didn't get who's coming tomorrow, I suppose.
Let's talk about the following week. So the following week, it's Wednesday. Is it Wednesday that we're not here?
Yes.
Okay. Are we going to be in a position, and Mr. Altenburn, to have a meaningful discussion about jury instructions maybe Wednesday afternoon? I've already kind of given the morning away for other things. I'm just wondering,
I was thinking about going back to Tampa, but yes, we can do that.
Well, I'm just trying to figure out when we're going to have time to talk about it.
I understand. Right, I sent a draft to Mr. Elegant on Sunday saying, please redline these and send it back. And that hasn't yet. And I bet that's because he needs to talk to them and they've been busy. By the way, I've also sent him a draft of what I discussed a couple hours ago with him, and I know he needs to still talk with them, but I would really hope I could give that tomorrow morning. So, but the rest of that, it also helps mean if we get by the DV, then we know exactly what the package looks like.
Well, I am certainly hopeful that we will have rested the plaintiff's case by then, and even if we have to do DVs over lunch or go late or something.
And I think by this weekend I'm going to know what all the evidence is, so I can try to put together my thoughts on that. So I'm ready to go whenever on Monday.
Yeah.
So I just wonder if Wednesday afternoon is an appropriate time to start talking about the jury instructions, given that, I know that not all of you have to be here. Maybe it's just Mr. Elegant and Mr. Altenburn to have this discussion.
Because I don't think I'm going to need to be in the courtrooms so much when we're putting on our case. So especially if we were doing our case on Tuesday, I could work with Mr. that'll get a whole lot before that meeting.
And I could probably even handle you all on Zoom
Okay.
If you wanted to do.
if you wanted to go
That way we-
to Tampa.
Yeah, we could even be in the same room together, probably, if you wanted to.
Well, you and Mr. Elliott.
Yeah.
Yeah, just so long as I actually physically had whatever you were looking
We
at.
work well together, work with so.
Do you think that's doable? Wednesday afternoon?
I do, but I'll send an email to Tom to see how far along he is on this as well.
Can you let me know like tomorrow so that if the answer is no, it's not doable, then I'll probably give the time away to others, but
Gotcha.
before y'all get first dibs on my time, so I just.
Yeah, I was hoping to have this done by the 20th of August, so I'd be happy to have them done on Wednesday.
Anything else?
Judge,
I was
just
just-
on Williams' rule on this has to do with Sally Smith, has to do with the parent agency, and I've got two witnesses, and they're going to say that Sally Smith walked in and did the same thing to them. She did the Kowalskis. Their testimony should take about 15 minutes each.
What is the specific issue? Because it's got to be. I don't have the list right in front of me.
Plan,
but-
motive, opportunity on 9404, substantially similar incident. So each one of these cases, in fact, one of them ended up almost identical to this, the Kushner case. And this is situations where Sally Smith walked in, either announced as a doctor or unannounced, wearing a lab coat and the badge, and then comes in, and, quote, examines them, asks a bunch of questions, walks out, and they never find out until much later that this was actually a doctor who was interviewing them towards a prosecution. And in both cases, of course, they did end up prosecuting, but that's not part of the question. That's just simply, the only question is, did you have this happen to you, so that we can show a plan, motive, or intent in terms of why they do it. And under 9404 and the substantially similar instance stuff, which I grant you is usually railroad tracks or things, but it would appear to be fall within that.
These are two people?
Two people.
And when do these events and where do these events occur?
When do they occur?
Yeah.
Well, actually, the Kushners happened within a year of the Kowalskis, and the other one about a year and a half, 2 years before. But I couldn't give you an exact date for the other one. I don't know it. I know the Kushner case because they're on the other side of it, and there's litigation in it.
I don't know the details of that, Your Honor, but the language in 404.2 on this is that you can get in symbol or fact evidence of crimes, wrongs, or acts that are admissible when relevant to prove a material fact in issue, including but not limited to proof of motive. I don't see motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. But it's inadmissible when the evidence is solely to prove bad character or propensity. And this smells like propensity evidence that we've done this before, so we can do it again.
Well, I guess my question, because I had to pull up the statute to Mr. Anderson, was because it has to be an element in the case.
Right. It's got to be not just a side issue, but a big issue.
Yeah, and so I'm struggling. I mean, it doesn't fit your medical malpractice.
A parent agency. It all goes to the agency argument, Judge, which is the key issue in the
But
case.
here's, and I was thinking about this the other day because, I had a chance to read this yesterday. How is it that, let's say they did, this is true that it's been doing lots of other families, but how does that impact what the Kowalskis understood
Right.
Dr. Sally Smith's role was? Because it doesn't go to what the Kowalskis understood, it's really what the Kowalskis understood.
Right.
So I don't think it goes there.
I think that's two different points. As the Kowalskis understood, it goes on the detrimental reliance and how much they told Sally Smith and what actions they took based on their beliefs that she worked for Johns Hopkins Children's Hospital. So I don't think the fact of identification and the plan that we argue was in place, which the defendants acceded to, was that Sally Smith would come in unannounced, and it didn't really matter, Judge, after that, what the circumstances were. It was simply that this was an ongoing pattern and plan of conduct in order to extract.
But if you're talking about
information.
a parent agency, it's got to be focused on the Kowalskis and their understanding, and what experiences other people had is absolutely not relevant to what the Kowalskis understood, which is why it doesn't come in under medical malpractice. And I'm not sure it comes in, what happens to other people under any of your other counts. So that's why I'm struggling to see how this comes
I
in.
think under the intentional infliction of emotional distress count, obviously Sally Smith is part of that. But I'm not going to I didn't plan to ask them, were you traumatized by Sally Smith misrepresenting? They were, but I hadn't planned to ask them about that. I guess I could ask them about whether discovering the misrepresentation, the subsequent prosecution, was harmful to them, and that would place it as a similar incident.
Unless you can come up with something really strong, I'm going to end up denying your motion, because I don't think it fits under 90.404 paren 2 paren A.
Because we're traveling under a parent agency is the thing, and that's...
And it does not go what experiences other families, and I'm not saying it didn't happen, it's just what happened to other families isn't within the knowledge base of the Kowalskis, and it's really the knowledge base of the Kowalskis that matters for purposes of your parent agency.
I thought, I'll have to check though. I thought we were in on other, let me check the plea.
So, unless something massive changes, expect that motion to be denied.
And just to buttress the record on that, there is a case called Trees By and Through Trees versus Kmart Corporation at 40467 Southern 2nd 401. It's a 4th District case from 1985. And it was reversing a civil case because something in this nature was done. Explaining this was a propensity and pattern of conduct were the same thing, and that's just a pattern of conduct, which is what I think they were just trying to explain. Thank you.
Thank you very much. Anything else?
No, but I just to quadruple check, because I'm so sorry. I was up very late last night and very early preparing for Dr. Anna. Again, because I'm hearing whispers and different people coming. The only people the Kowalskis are bringing tomorrow, again, are the DCF coordinator, 3 Kowalskis on damages only, and the 2 depot designations, correct?
At that time, we have sent over the list, including Deborah Salisbury.
And we're evaluating whether her testimony is necessary at this point, or she would be a rebuttal witness. But we will let you know one way or the other if I have a chance to speak with her after we get out here.
I guess the frustration with this, and I know it's very late in the day, is unless the plaintiff wants us to be doing this to them, in our case, throwing 7, 8, 9 witnesses that they know they have no chance of us getting through, it's very frustrating to hear that we now have a lineup of 7 to 8 witnesses that are going to span 9 to 10 hours. We know we're not getting it through.
It's been a constant pattern throughout the.
Well,
But anyway.
it sounds like Ms. Salisbury is probably going to ultimately require some sort of proffer before.
Right.
And so I wonder if, from a timing perspective, is that something that is even doable tomorrow, given everyone else?
I think what I'm trying to evaluate is the scope of what she can say and not get into the wrong area. And I can't assure the court of or counsel the breadth of that until I talk to her one more time.
Well, what it sounds like is she should not be a witness tomorrow, perhaps on Friday, but not tomorrorow. Is what I'm hearing, but just from a timing perspective.
That's fine with us.
Because that means someone gets to go to bed at midnight as opposed to 2 a.m.
On that program, yes,
Okay.
We'll move her till Friday if we do decide to use her.
Thank you.
That's all right.
Thank you. Have a good night.
Thank you.